to order the meeting of July 18th, 2018 of the Ojai Planning Commission. Members of the public wishing to address the Planning Commission on items appearing on the agenda are requested to complete a speaker's card. A green card like this, you'll find one in the lobby, and file it with the secretary. Speakers should state name and address for the record, and please let me know, do you live inside or outside the city of Ojai? And limit your comments to 3 minutes or less. Comments must be directed to the commission, not the audience. While Planning Commission is in session, all in attendance are expected to maintain order and decorum and obey the orders of the chair. Thank you. Chair, do you have a roll call, please?
Chair Quillisi?
Here.
Vice Chair Nolan?
Here.
Commissioners Merck?
Here.
Corbin?
Here.
Jagiello?
Here.
Powers is absent and one vacancy.
Thank you very much. Commissioner Merck, would you lead us in the pledge, please?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. All right, the next agenda item is public communications, the time set aside during the Planning Commission meeting for members of the public to address the Planning Commission on items of city business other than scheduled agenda items. Matters raised at this time may be briefly discussed by the Commission and will generally be referred to staff and/or placed on a subsequent agenda. Under state law, other than for emergency items, no action can be taken in this meeting. And for those that are not familiar with the process, please understand that there is generally very little response from the Commission to a speaker under public communications. Do we have anyone here? I don't see the markings on these cards. Is any one of these four, Wendy Hilgers, Kathy Richards, Bill Miley, Vina Lustado? Hope I did that right. Any one of you wishing to speak on something other than an agenda item? Is there anyone else that wishes to speak on other than an agenda item? Mr. Daddy, please step up.
Chair, thank you. I'm not sure where you're going to get into discussion of the building board and the review we went of the city codes. You're the liaison to that. You were in that meeting. And I'm hoping that the Planning Commission can take a look at the work done by the Building Appeal Board. We carved a huge section out of the Title IX. We're making a recommendation that it be moved over to 10. That clearly should be with the Planning Commission. It clearly is zoning. It clearly is land use. It is clearly not building components. It clearly is not recirculating water or solar hookups or those type of building things. And I'd really urge you to take a look at those things as quickly as you can, adopt what you can, incorporate that into what you do, and make a recommendation to can a lot of these things that are irrelevant. They've been left over, a number of them, since 1965, and it really shouldn't be in our codes. I would also urge you to please speed dial through your codes, which are going to be long and gruesome. You've got tons of them. And take a look and see those things that are just totally irrelevant that are in there, that confuse the people. They try the best they can to look through our codes. Our codes are contradictory, they're vague, they're just all over the place. And sometimes, if you're going to put a little tiny fence under a tree, you have to look in 5 different sections of the code to find out if you can put a little 3-foot fence under an oak tree between April and August. That's something that should be cleaned up. That's just not fair to the community. So I would ask you as the Planning Commission to look at those things we're referring over, and then take a look at those things that we really shouldn't have here. Thank you.
Thank you. I did attend that meeting where the Building Appeals Board went through about 7 or 8 chapters, I think, of Title IX. And I was expecting a whole lot of clarification, and there was a great deal of that. There was also, I felt like, a great deal of passing things to the Planning Commission. And now we have to deal with those same things. They are land use and zoning, I think, and so because the Planning Commission has also been asked by City Council to look at cleaning up Title 10, which, as Mr. Daddy said, is long and onerous, especially 10-2. That's something we're going to get to as quickly as we can. We have a few other things in the pipeline, but I'm thinking we're going to have to make some assignments of people to read chapters of Title 10 and report back to the commission with recommended changes, if any. So, any other persons out there that would like to speak on an agenda or on a non-agenda item? Okay, we will close public communications and we'll go to the consent item, the minutes of the regular meeting of the Planning Commission, June 6th, 2018. The recommendation from staff is approved as submitted. Is there any discussion? Have any of the commission members found something that should be modified in the minutes? I did note, by the way, that we did get some new direction from I guess from the city manager, that modifies the way the minutes are going to be recorded to synopsize what people had to say when they spoke, rather than trying to catch everything verbatim, which will make the minutes a lot easier to read through for the commission. If you're still interested in more detail, it's always out there on television. If there's no corrections to suggest, I'd entertain a motion to approve the minutes. Yes.
I will make a motion that the commission adopt the June 6, 2018 Planning Commission meeting minutes.
Okay.
I'll second.
Okay. Any other discussion? Could we have a roll call, please?
Merck,
Yes.
Corbin,
Abstain.
Nolan,
Yes.
Quillisi,
Abstain.
Jagiello.
Yes.
Great. Just enough people that were there to approve it. Is that another speaker's card? Great, okay. All right. Now we'll move to a public hearing item, and that is movable tiny houses text amendment. And we have some recommendations. I'd like to hear from staff.
So I'll keep this initial report brief. This ordinance was previously before the Planning Commission at the last meeting, May 16th, 2018. It had been directed to return to the Planning Commission from Council with a request to make a recommendation as this ordinance pertains to movable tiny homes, and as mentioned last meeting, integrates movable tiny homes into the existing accessory dwelling unit section of the city code, essentially treating them as a smaller mobile pre-built version of an accessory dwelling unit. They are also capped in this ordinance at 440 square feet rather than the typical 1,200 square foot accessory dwelling unit. They are not necessarily affordable, but could be affordable. And as Chair, or actually let me respond to a couple of quick points from questions that came up at the last meeting. Staff, and this was mentioned in the staff report, but staff has spoken with HCD regarding the question of whether these units would count towards the city's RENA housing units. At this time, they will not. And HCD essentially said, it's a new area, we're looking at it, it may in the future, but they will not be counted at this time. We also spoke with Fresno, which a couple people had asked how many tiny homes Fresno has permitted under their permit, which is similar to this. I spoke with their community development department, and they have not permitted any at this time, but they have had people come to the counter and ask about them, but they haven't had any permitted. Finally, the property tax question, which I think actually was, in hindsight, was answered at the last meeting, but essentially the answer on whether these would be subject to property tax is whether they are affixed to the property. If they're affixed to the property and they're permanent, they will be, they could be reassessed and have an effect on your property tax. If they are mobile, they will not have an effect on your property tax. They're essentially treated the same as recreational vehicles if they're mobile. And so there's a couple of key issues that we're hoping that the Planning Commission looks at. They were detailed in the staff report, which is recommendations regarding the utility requirements, the duration of the stay period for the homes, which is currently set at 12 months in this ordinance, and the section 4K that refers to the exit requirements and emergency and rescue openings. We would want to get direction on whether Planning Commission has any modifications to that. And then, as Chair Quillisi noted, the key issue for Planning Commission at this time, you noted this at the last meeting, is whether the Planning Commission would like to recommend that council adopt this ordinance, recommend that council make changes and adopt the ordinance, or recommend that council does not adopt the ordinance. And those are essentially the major questions before you.
Okay. Any questions for staff? Oh, I'm sorry, Mr.
Thank
Summers,
you.
please.
Thank you, Chair, members. Just a couple of further comments to add, I think, to help advance the discussion. One, as Interim Director Vega noted, HCD's initial position, we haven't yet got a word from their top-level policymakers, and we're hoping to get that word sometime. Moving them forward can be difficult on whether or not tiny houses, if approved as structured as a species of ADU, would count as moderate income by design, moderate income affordable by design for RENA purposes. So to date, they have said no. I'm not sure that's the final answer, but that is the current answer. And I would, we will, of course, if this is approved by the council, seek to work with them on that, particularly taking into account that with respect to a movable tiny home that is brought onto a property and then the wheels are removed and it's affixed to the property, that functions the same as any other semi-permanent housing, such as a mobile home, a traditional mobile home, and should be counted for RENA purposes. But like I said, moving HCD forward to a decision can be difficult, and we would be working, if approved, working with HCD staff to get a definitive answer from them at a high enough level where it can then be taken to the legislature if necessary. The initial answers have been kind of the on-the-ground preliminary answers,
Okay.
not necessarily high level.
Moment HCD is silent in writing.
In definitive writing, yes. The initial writing is no.
Okay?
I realize that's a perhaps unclear answer. The second one, and this, I think you've been provided some commentary as well from the Ojai Valley Sanitation District through email submitted. I think these are printed on your letterhead, Chair. Ojai Valley Sanitation District has taken the position that no matter how we structure it, no matter how we constitute it, a tiny house is subject to their permitting requirements, their ordinances, and their capacity charges. That position is not necessarily consistent with the city's previous positions, particularly with respect to certain species of tiny houses, rather of ADUs, but of course tiny houses are not within the house, so they're not within the existing allowance in existing state law for no fees from sanitation districts. However, the ground is shifting underneath us because SB 831, a bill put forward by Senator Wajkowski that's pending in the legislature right now, would change the rules regarding what agencies can charge what kind of fees for ADUs. And if that changes the way some expect it to, depending, of course, on what the legislature passes and what the governor signs, that would change the defensibility of the sanitation district's position. To date, their position is, as I noted, that these are still subject to their permit requirements and to their capacity charge. The ultimate survival of that will depend on the decisions made by the council, the decisions made by HCD with respect to how these are classified, and the decisions ultimately made by court, if litigated. And the Actually, that's the last point. Available for any questions. Thank you.
Okay. Yeah, I know, as I think all the commissioners here know, that through a series of state laws over the past 2 or 3 years, the connection charge from the sewer district is no longer valid for an ADU. The capacity charge is a different sort of animal, and we'll just have to wait and see what the legislature does about that, I guess is what you're saying. At the moment, the sewer district contends that a change in your capacity charge is legal if you have a tiny home on wheels in your backyard.
Correct. Their contention is that that's legal. The city council's previous expressed contention is that, at least with respect to regular ADUs, is not true. The matter has not been litigated, and the legislature is in the middle of writing new law.
I don't know, has the issue ever come up with regular ADUs, with stick-built?
Yes, it has. The district has asserted that they have the power to impose the fee. The council has disagreed. I do not believe it has been litigated yet. Certainly not by the city. I'm not sure if any homeowners have filed suit.
Okay, do you know if the city council has taken a formal position
The
on that
city,
assertion?
the city issued a letter some time ago, if I remember correctly, to that effect. We can confirm that. But
Okay.
the key point is, for purposes of tonight's discussion, whether or not the sanitation district will impose its fees isn't a question that can be answered, and thus isn't necessarily a point that has to be considered. As Chair Vega noted, the focus is on land use questions tonight.
Go ahead, Chester.
Matt, do I understand what you're saying is that the tiny homes is being treated differently than a traditional ADU?
That is the position the sanitation district has taken. It has never, their
And
position hasn't been defended in court. No one's litigated it yet.
Right, and when did they make that assertion?
My understanding, it was done by their executive director in an email yesterday.
Wow, okay.
There's a lot of reference to Table A, subsection D. Can you tell me where I'll find that?
Certainly. Table A subsection, Table A is a portion of Ojai Municipal Code, Section 10-1709, which is the main provision that speaks to accessory dwelling units. And
Okay.
that's available in the city's code, and
I don't have it here.
it
Okay.
perhaps wasn't included in the packet. Apologies for that.
Yeah, it was not part of the packet, although we have extensive documentation
Well, if
for
I
other
knew it
parts.
was in that, I would have
Yeah.
gone into the garage and gotten it out. I just thought it was supposed to be in here.
I note also that in addition to the questions of utility requirements, increased duration of stay, and the exiting requirements, we also have the question of ANSI versus building code. Is it good, bad, indifferent, or irrelevant that movable tiny homes are built to a different set of standards? I don't believe that building standards are a topic that the Planning Commission should be discussing. That's something I believe that the Building Appeals Board should be discussing. Yes, ma'am.
I was just wondering if, in fact, it's placed on a permanent foundation, then do the building standards kick in?
I think we may need a reading from the city attorney on that.
Happy to speak to these points. Answering the question in the reverse order. If the ordinance that's proposed is approved by the council or something similar to it, then a tiny house could be built under the ANSI standards, brought into the city, and then placed on a permanent foundation and affixed. And it would not need to meet the building code. It would need to meet the ANSI standards. If based on the current structure of the draft. The city can choose whether to apply the building code or whether to apply the ANSI standards to this type of non-stick-built permanent structure.
Under this proposed ordinance, the city could.
Right, well, and this ordinance would be making that choice.
Yeah.
So the Planning Commission has the power to recommend to the council whether it's supportive of that approach. But the Planning Commission isn't the correct body to crack open the ANSI standards and decide how those should be rewritten. In staff's position is really that would even be, that making that kind of a decision could of course be directed by the city council, but that would be a significant use in resources that would take a council decision to whether or not to direct staff to develop a new standard, as opposed to making the choice between should tiny houses be approved using the ANSI standard or not. That's the decision point facing the council that this commission is asked to make a recommendation regarding.
Right, and what I'm saying is, I think that the question of building standards is something the Building Appeals Board should take up and make its own recommendation to council. Building standards are not within the purview of the Planning Commission normally.
Correct. If the council chose, they could refer the matter to the Building Commission, to the Building Appeals Board. I don't think it needs to go to them organically. That would be up to the council as well.
It would not be something that the Planning Commission could recommend?
The Planning Commission can certainly recommend it, yes.
Okay,
But the decision point there lies with the council.
okay. Chester?
On that same,
Excuse me.
on that same note, in your staff report, you talk about the city would not have building approval or building inspections authority over movable tiny homes if built and certified as ANSI standards. And then we go into the actual ordinance, and we're talking about section K, page 5 of 7, where it says the emergency and rescue openings, which are, now you're quoting California building codes, which are different than ANSI codes. And we brought that up at the last meeting, and I'm still not sure how you can have an ANSI-created tiny home show up on a site and then demand to apply a code from the California Building Code.
You want to take that? It would be a policy choice for the commission and the council, in heart for the council. One thing that is worth pointing out is the council could choose, upon the commission's recommendation, to simply adopt the ANSI standards and delete this additional emergency rescue opening provision. That's one choice. Another choice would be to leave this in place, and then it would be up to a proposed tiny house owner or occupant before bringing the tiny house onto the property to secure the permit, and thus, in part, to make sure that the design meets the standard, including that additional standard. And that's perhaps one point that's worth bearing in mind is that the underlying concept isn't that tiny houses could be plopped onto a property in the dead of night and then it would be up to the city to permit it or be forced to go to court to remove it. It's up to the applicant up front to apply for it, the same as any other property, any other building. And that may assuage that concern, because in that case, an applicant looking at adopting a building, securing a tiny house for their property, would have to come in, ask for a permit, ensure that it meets the setbacks, that the other standards that are proposed, and this additional standard, if adopted by the council, and would have the opportunity at that point to determine whether it does or does not, their proposed design does or does not meet the standard before they bring it onto the property.
So I understand then what you're saying is that you can combine the two if you want. I mean, we're saying at one part that we're going to accept ANSI standards, but we're also saying that we could apply California building codes as well.
If the council makes the choice in this context, yes. But again, the key is that
I just felt that kind of conflicting in the report. It doesn't seem, because here we're saying as long as your tiny homes, most of them are already built ANSI standards, right? And they're going to come on site, and now we're going to ask everybody to retrofit them to a building code. That's
I think that's
still not sure
part of the
how
policy
that-
choice. It also, and this is perhaps the tiny house builders would have more information than those of us here. As it was explained to me, this standard derives from the Appendix Q of IRC, the International Residential Code, which was put forth by several tiny house advocates in previous meetings as a standard to apply.
Mm-hmm.
This was adopted from that standard and then added on top of the ANSI standards to promote further safety. It's not set in stone. It can be changed.
I
Perhaps that may be a question for
actually
the-
agree with it, because I think it's a good safety thing to have egress and to do that. And I understand most of the tiny homes that I'm familiar with have that built into them. So, yeah, but it's more of a technicality when we're saying we're not enforcing code. We are enforcing code, some code, if we choose to apply that, correct?
Correct, and perhaps the staff report could have been phrased a little clearer.
Yeah.
The city doesn't just accept an applicant's assertion, oh, I built it to ANSI standards.
No, they need
It needs to be
certification. I get
certified.
that. Yeah.
And the city would ask the question, if a tiny house applicant was here, we're at the counter, they show up, the city would ask, okay, so you assert your tiny house is certified, prove it. Where's your certification? What year was it issued? To what set of the ANSI standards was it approved? That would be the question that would be asked. And then the city would make the judgment, evaluating which certifiers are appropriate. If it's, the fly-by-night certifiers in CRAN, that would not be accepted, versus one of the many industry standard known individuals would be accepted. The same is typical now in other contexts.
Go ahead.
Just a comment, following Chester's stream there. So essentially, let's just say that this city council adopted this ordinance. It would have to be known, and a property owner, let's say if they wanted to get, put in a tiny home on wheels, would have to get this information ahead of time before they had it even built, and make sure that for the loft space and the exit space that they were including the building code standard in addition to the ANSI standards for the rest of the structure.
Right,
So I
that would
think
have to be made very clear.
Right, so be very clear and,
That's the requirement.
right, because, somebody could potentially have one built, go through the whole process, get it there, and like you said, that component may be missing, then what? Retrofitting
have
it
to
may
retrofit,
be
yeah.
an issue.
Yeah.
Okay, well, I just wanted to be clear on that. Thank you.
I haven't sensed that we're going to have a lot of parcel owners in the city contracting to build a tiny home on wheels. I suspect what we have instead is a number of folks from outside the city who are in the business of selling tiny homes on wheels, who will certify or self-certify or whatever, and then a parcel owner would take that documentation as whatever level of proof is required. Mr. Summers, you mentioned the IRC, the International Residential Code. Has the city council adopted any portion of that at any time?
No, city council has not adopted IRC. The relevant provision in IRC has been baked into the state adopted building code, which has been adopted for the city by fiat.
Okay, and the city council has, from time to time, adopted the California Building
Well-
Standards Code, either directly or indirectly, I guess.
Right, indirectly would be the phrase. The California Building Code is adopted for the city unless the city makes local modifications. The city did not make local modifications this year, although I believe the Building Appeals Board may still be considering the matter. I think the Building Appeals Board is still considering the matter. To date, the city council has not made modifications of the California Building Code. It was adopted for the city by the state. The council hasn't made a choice to do so.
Okay?
And I'll turn to Interim Director Vega for additional comment.
Just to add, the Building Appeals Board has considered that, and it has actually made recommendations that are going to be going to council in the next couple of months.
I saw some of those at the last meeting, yeah.
Mhm.
Okay, back on ANSI versus the California Building Code for a moment. Is city staff in a position to judge whether the ANSI standards provide the same level of public safety, et cetera, as the California Building Code for a structure of this sort? And
So-
if not, is there anyone, it might be the Building Appeals Board, might be someone else, how do we resolve the question of, are we protecting the citizens of the city to the same extent, looking at this as permanent or semi-permanent housing as opposed to a trailer?
That is a challenge for city staff. And one of the points we make in the ordinance is that if we did go with ANSI standards, that we'd have to have a qualified third-party inspector to inspect, because the building official and the building inspector are not ANSI experts, and we don't have anyone on staff who is qualified to be doing inspections on ANSI, or that would have an immediate knowledge of what the ANSI standards are. essentially, and I'm sure you're aware, but those ANSI standards are the same standards that are in place for recreational vehicles. And so it would just be in line with those. But no, there's no person on staff who is an ANSI expert.
And perhaps a further comment, the heart of what you're asking is really a policy choice. Does the city accept the ANSI standards as sufficient to protect the residents and occupants of a tiny house? And that's a question fundamentally for the council.
Yes, and the heart of that is there a basis for saying yes or no to that question, that basis being known to the city council?
And the question, and whether to ask the question and how to answer it, those are both council policy choices. If directed by the council, staff would, of course, not necessarily become an expert in ANSI standards, but would become an expert in evaluating the third-party certifications that are presented by applicants. And one further point there, as proposed, this ordinance would prohibit self-certification. I know that phrase was mentioned at one point by some prior commenters. This ordinance prohibits self-certification. An individual could build their own tiny house, sure, but they would need to get a third-party inspector who's qualified, meets the city standards to certify it.
Okay? Go ahead.
Are we done with that subject? I got some
I
other
think
questions. I got another question on another topic. I heard you say that the city of Fresno passed the ordinance, and I believe that was over 3 years ago. And to date, they have not have one permit for a tiny home.
Correct.
I find that shocking.
Have there been
Wow.
applications for permits that were denied, or is it just no one has asked?
So they have had several people ask about them, come to the counter, ask for information, the pamphlet, a brochure, which we were talking about. Obviously, we would do that here as well. But they've asked for that information, but they haven't pursued it any further at this
Okay,
point.
so there have been no applications for permits?
Right.
Okay. Okay. Please, go ahead, Bobby.
And where are we with the utility connections? Are we saying that it needs to be hooked up to the main sewer line, or are we still talking about off-grid possibilities?
It's still, as written, allows for off-grid possibilities, subject to approval from the director and the building official.
But we determined that the composting toilets were not legal, isn't that correct?
The sanitation district has asserted that the composting toilets are not legal. As that assertion came down yesterday, staff hasn't had a chance to independently verify it.
Because
Who certified that?
Mr. Palmer, the director of the sanitation district,
Oh, okay, well.
he has asserted that composting toilets are prohibited within the city. Staff hasn't had a chance, as that came down just yesterday, to independently verify that point.
Mr. Palmer has, with all due respect, a vested interest in the answer to the question.
And that's not to
I'm
knock
not
Mr. Palmer.
criticizing.
By any measure, I'm not knocking him. I'm just stating the
Right.
facts.
If it provides any clarity at all, I have spoken with a gentleman at the Ventura County Resource Management Agency Environmental Health Division. And it is his assertion that composting toilets are not allowed in the county, and that if one wanted one, that it would require a waiver request through the Environmental Health Division of the Ventura County Resource Management Agency, and that division, if it approved the waiver, would have to turn around and make a similar waiver request of the Los Angeles Regional Water Quality Control Board. And it is the Environmental Health Division's position at this point that they have not had any requests, that if they did, they would not approve a waiver, and they would certainly not request a waiver from the Water Quality Control Board. So, from a practical point of view, assuming the city is going to do the right thing, which is if someone wants a composting toilet in a tiny home on wheels, they're going to have to ask for a waiver through the county. And so far, that's not going anywhere. Go ahead, Chester.
On the subject of utilities, it also states in the ordinance on page 5 of 7 that we shall not have separate utility meters for the primary unit, from the primary unit, and we shall not have a separate street address. What is the wisdom with that? Because, for instance, for most ADUs, they can have a separate service, and they can also have a separate address. They're demanded to have a separate address. In fact,
Metering is up to the parcel owner.
right, but this says shall not. So I'm just wondering what is the reasoning for that?
So for the addresses, so there's two components there. For addresses, because they're movable tiny homes and they aren't permanent, we wouldn't assign a permanent address to them. That's basically what that boils down to. If they put them on foundation and they became permanent, that would change things. But while they're movable, they wouldn't have an address.
Okay.
Okay.
And how about the utility hookup? Why couldn't you have that on a separate meter? What's the idea
If I were a
there?
parcel owner and I was going to have a tiny home on wheels in my backyard, I would think that I would want to have it separately metered. If it's family and friends that are living there, that's one thing, but if it's someone, a third party who wants to live in my backyard, I don't think I'd really want to have their electrical use, for example, aggregated with mine, which will drive my bill to a higher tier of usage.
Yeah, I had a comment
Yeah.
too. And I know we've had this in past discussions. I'm just generally in favor of having a standardized utility protocol for all ADUs at this point. I mean, down the road, sure, I'd love to see, somebody be off-grid, but because it's not in the code yet, I'd almost like to see it standardized between all ADUs, whether it was a tiny home on wheel or
I
permanent
agree.
one
I
on
agree with that.
foundation.
That's why I think it also should have a separate address, because
Right.
there's fire, there's reporting, there's police. You want to be
Right.
able to separate and identify
Exactly.
that there's a second dwelling on that property.
Right, and then sometime, down the road, if for whatever reason, you can go off grid, whatever that means, it would be across the board for all residential
Yeah.
units, so.
Let's continue this in the vein of questions for staff at the moment.
Okay.
And some of this, I think we can save for deliberations
Okay.
later. Mr. Vega?
So for the utility connections, I think that would be a section that Planning Commission could make a recommendation on. I don't see the
All right.
importance of it.
And it certainly could be the case that the commission recommends to the council that the standard be the same as regular ADUs,
Right.
which, if I remember correctly, leaves it up at the option of the applicant whether there is or is not a separate connection.
Okay.
As far as the address, I recall one of the chapters of Title IX that was considered by the BAB at its last meeting had to do with addresses. I don't remember if that's one that they threw over the transom to the Planning Commission, or that's one that they recommended in some form to the city council. But in fact, that portion of the code says if you have more than one structure on the property, then the primary residence has an address, and a second building, a second habitable structure of whatever sort, has to have that same address with a B, Bravo, attached. It wasn't clear to me whether the primary address had to have an A on it, or anyone else could have an A, but it seemed to me the second structure had a B address, and I may have misremembered that.
But-
And I'm wondering why it's not like that here.
Yeah, I think you're correct. It was the second structure would be a B, and then the discussion with the BAB was whether the first needed to be an A or could just be
Just could
the
be
address,
the
the number by itself.
Yeah.
Yeah. But again, I think because these are movable, that the addresses aren't affected in this case.
My thought would be movable or not movable, they're separate structures that are likely to be occupied by a third party. And I would think that third party would want to have their own address for mail purposes.
And for safety, as Chester had mentioned too.
Right.
If you need an emergency,
Yeah, for
police,
fire
fire,
and
ambulance.
police,
Yeah.
you know, they,
Okay.
to identify, the A/B addresses really do help
Yep.
identify immediately that there's a second dwelling there on that property.
I think that's a recommendation that you could
Make, right.
send,
Yeah.
add to the council.
And I have one more
We have no
recommendation.
objection to that.
May I, may we-
Please.
And one more item here, since we're going through the ordinance here, on the 100 square feet minimum, how did we come up with that? That's on page 4 of 7, letter E.
That recommendation, or actually, I'll let the interim director speak to it.
Well, we based this on the Fresno ordinance, and that was taken from the Fresno
Okay,
ordinance.
got it. But that could be modified, obviously. Okay,
Okay.
that's all my question.
Any others? I have a few questions. I just wanted to let the rest of the commissioners wind down a bit, if you will. In the staff report, page 3 of 4, under the question of utility requirements, it says, since most movable tiny homes are self-contained, and I'm not sure what that means. I could understand if there were solar panels on the top that one could say electrically they're self-contained because they can generate their own electricity. It's less clear to me how a movable tiny home will generate its own water and how it will dispose of any waste, all self-contained, given the county and the regional water quality control board current thinking on composting toilets or whatever. So it's not clear to me what self-contained means there, what it was staff's intention to convey to the commission. And from a practical point of view, is that a realistic term to apply?
It could be modified. It's also in the ordinance. It's defined a little bit clearer. It's on page 4 of 7, subsection F. Detached self-contained residential dwelling unit, which includes permanent facilities and functional areas for living, sleeping, eating, cooking, and sanitation.
Well, in that description fits most ADUs. But is the rest of 10.2.1709 describing other types of ADUs as self-contained?
That's a good question. That section does apply to second residential units. I don't recall if we defined, or if we,
I just
That's
didn't,
not
I
the
didn't
updated
recall
one.
seeing that language anywhere else in the ADU ordinance.
The regular ADU ordinance would define it, it may not have the phrase self-contained, although we'll confirm, but it does speak to separate functional areas for living, sleeping, eating, cooking, and sanitation. That's what defines an ADU, is distinct from just a second room or a bonus room or something.
Right, okay.
But that's a little bit different.
But
Than the
a
question you
stick-built
posed.
ADU is gonna have normal utility connections. Whether they need natural gas or not is a separate question, but certainly electricity, water, and sewer are gonna be part of I'll call it a normal ADU for the moment, because this is a special category.
Right, the other categories of ADUs would all have all standard utilities. The only question would be whether or not they are or are not separate from the primary, but that's just irrelevant to this particular point.
Okay? Go ahead, Kathy.
One other question, and this, it gets back to the utilities. Item F on attachment A, page 5 of 7 at the top of the page, is referring to mechanical equipment. And I'm not sure if you would call solar panels necessarily mechanical equipment, although they are the collection device. Would this basically not allow solar? Or would that be considered mechanical or something other than that?
Apologies, could you repeat that question? We were looking at the prior
The
issue.
question is, what does part F mean?
Mechanical equipment, I was just saying, would solar not be allowed and included as mechanical equipment? Or, I know it's a collection device.
yeah, we intended that to refer to HVAC, heating. and
Okay,
air
so
condi-
solar would be fine?
Yeah.
Okay, I
yeah.
just wanted to
So
be
it would be
clear.
better to clarify
Yeah,
that.
that's
Yeah.
a clarification we
Okay,
can make.
good. Just, sorry, Steve, go ahead.
Any more? Okay. Whether this is specific to movable tiny homes, I suspect it may not be, but I've distributed to the commission members as well as the city attorney and staff, the Casitas Municipal Water District Resolution 1308, and a letter from the Assistant General Manager, now Acting General Manager, I'm told, of Casitas, talking about the charges that result from the water bond that the city passed some years ago for the buyout of Golden State. And there's a piece of Exhibit 1, a table of properties and tax charges. And the point of all this was to say that the water bond tax assessment depends on the size of the parcel and the number of residential units on the parcel. And so if you look at this exhibit, this is just like page 27 of 57 or something, I don't know. About 8 lines down, there's a assessor's parcel number that ends in 191040. That happens to be my property. Says it has 1 residential unit, and you can see it, my tax assessment is about $100 a month. If you go about another 8 lines down, there's 192090, another single-family detached, same tax class, 3 residential units, 3 times the water bond tax. And my question would be, does a tiny home on wheels qualify as a residential unit? I think the intent of the ordinance is to make it a residential unit. And I'm wondering if either a parcel owner who wants to have an ADU understands that they are going to have additional water bond taxes levied on them. This is through the property tax rolls, by the way. And I'm wondering if a tiny home on wheels is going to be considered a residential unit, or is it still personal property because it's regulated by the DMV and has a license plate on it? And a further question to that would be, if you pull this movable tiny house into your backyard and you put it up on blocks, take the wheels off, do you also take the license plate off? Is it no longer regulated by the DMV? And these are questions perhaps for our city attorney.
Sure. To answer them in turn, with respect to the Casitas Municipal Water District, Community Facilities District Number 1 special tax, I am not sure what position they would take. We haven't considered the question. It's a bit beyond this commission's consideration, so we haven't analyzed it for today's meeting. In the end, it will matter what decision is made by the Community Facilities District and what decision is made by the County Auditor Controller as the 2 entities who collect that special tax. The matter of property tax, we have spoken, or staff has spoken with the County Auditor Controller on that question. That is the 1% property tax. And their conclusion is that movable tiny houses that retain their DMV assessment would be
Retain their movability.
retain their mobility, yeah, and retain their DMV licensure, et cetera, would not trigger a property tax reassessment, but that if it was moved onto a permanent foundation, affixed to the land, separated from its wheels, and made permanent, then the county auditor controller has stated that they would consider reassessment and thus assess property taxes on it. That event may then trigger assessment of the Community Facilities District special parcel tax. But again, that question isn't one that I can definitively answer because it will not be up to me. It will be up to the Community Facilities District in its tax collection, and then the auditor controller. And the last question with respect to DMV licensure, I think that would really be up to the applicants. If an applicant moves a movable tiny house onto a property and keeps the wheels on and just skirts them as required, then they would need to maintain their DMV licensure. If they move the property, move the movable tiny house onto the property, remove the wheels, affix it to the land on their permanent foundation, then they may not need to maintain their DMV licensure. But if they wished to later move it off, de-affix it, lift it off and move it, then they would need to resecure their DMV licensure.
And that would trigger a property tax reassessment again? Or would that be at the request of the parcel owner saying, I no longer have a movable tiny house, or I no longer have an movable tiny house on my property, therefore I'd like my taxes reduced?
Generally, the county auditor controller does not automatically assess down. They only automatically assess up. So it would be up to the applicant. That's just a general rule. The applicant would need to apply to reassess down.
There are appeal procedures in place, I'm sure.
There are appeal procedures. There's a process. The county auditor controller, and this perhaps is general knowledge for those in government, but maybe not for the general public. The county auditor controller receives periodic copies of permits, and building permits in particular. That's how they reassess properties. So when you apply for your permits, then it's reassessed automatically. That process is automatic on the way up, but not down.
Okay. A permit requested
Assessor,
for a
sorry, not auditor
movable
controller. Yeah, sorry, it's the assessor's office, not the auditor controller.
Yeah.
Wrong portion of the county.
assessor's office, right. I spoke with someone in the assessor's office myself as well, who said their current policy is that a movable tiny home, we'll use the phrase for the moment, is regarded by the tax assessor's office as, quote, a parked trailer and as personal property. And the taxes that are levied on it are personal property line on the registration of the trailer itself. I'd like to go on to the ordinance itself, and we're in attachment A, page 4 of 7. At the very bottom, paragraph E, 4E, says pedestrian access, an all-weather surface pedestrian path from the street frontage to the main entrance of the movable tiny home shall be provided. Does that require a building permit? Does that require an inspection to ensure that an all-weather surface is there? If it involves ground disturbance, does that mean we have to do a PAW on that parcel before we can do the all-weather path, before we can get the permit to tow the tiny home on wheels, movable tiny home into the parcel?
Yeah. It could. I think it depends on what all-weather surface path you end up putting in. If you end up digging and disturbing ground that wasn't previously disturbed, then yes, it would require a PAW, but not necessarily require.
Okay.
But putting that path in would not necessarily require that.
Okay, but the path itself is required, and who decides what is an appropriate or adequate all-weather surface pedestrian path?
That'd be part of the inspection process, which
And the director.
would be the director and the
This is the community development director?
development director.
Okay,
Correct.
it's not the building official, we're not talking about building standards here.
Right, community development director.
Okay, yes, go ahead, Kathy.
Does this also apply for all ADUs, or is it just for the movable tiny homes?
The all-weather surface pedestrian path as proposed is just the movable tiny homes, not regular ADUs.
So it could be, we could alter that if we wanted to.
Correct.
Okay, thank you.
Okay, we talked about separate utility meters, we talked about compost and toilets not being currently legal. On attachment A, page 5 of 7, paragraph G, near the top of the page, it says movable tiny homes may be off-grid and not connected to one or more utility systems, but only if the applicant provides sufficient proof to the satisfaction of the director and the building official. Now, the building official is involved, that the movable tiny home has adequate, safe, and sanitary utility systems providing water, sewer, heat, cooling, and electric power. And I'm wondering what staff's position is on what other adequate, safe, and sanitary sewer system there is other than a connection separate from or through that of the primary residence is acceptable. The language to me is a bit on the vague side, and I want to be sure, as I try to every time, that if we have rules in place, they should be written, they should be clear, and they should be understandable by the ordinary citizen who walks in looking for a permit. So if a citizen came in, what would this mean, adequate, safe, and sanitary utility systems? What does that mean for electricity? What does it mean for water? What does it mean for sewer? I'm looking for some clarification of the ordinance.
Yeah, and I think it gives the ability to take those on a case-by-case basis and look at things like, for sewer, for example, the option, if somebody does have a septic set up, that would be satisfactory.
Well, if a parcel owner installed a second septic field.
Or already had an existing permitted licensed septic system that had sufficient capacity to handle an additional unit, they could connect the one to the other.
Okay.
If permitted and licensed.
I could well be wrong, but I thought I had read elsewhere in the code that if you had an ADU or a guest house or something, and you had a septic system, that you had to install a separate septic system for that second structure.
We
Was I-
canceled that
was
on
I
the
wrong
last,
about
yeah,
that?
we got rid of that on the
I
last
believe
ordinance.
that has
We
been
did, okay,
removed
We
from the
deleted
code.
that.
Great. Let's take up water.
You know, I think,
I think we're all feeling like we shouldn't be running a hose from a faucet on the primary residence to a tiny home. But how will staff look at that? How can staff write something into this proposed ordinance that makes clear what is acceptable and what's not?
So there's two questions there. I'll take the reverse order. The challenge in writing an ordinance is to capture, either write every single case and have, but then say, these are the options, and just list cases. And then but one could be missed, or technology changes, or situations
Sure.
change. The alternative to that approach is what we've proposed here, which is just a proposal, which is to not seek to capture all cases, but instead set a standard that must be met. The standard being safe and adequate as judged by the professionals who are empowered by the council, the code, and the voters to make those judgments.
That being the CDD and the building official.
Correct. That's the alternative approach. Certainly, we can add clarification. We can shift to the other approach. We can add clarifications, but that's the basis on which this is proposed. I realize it doesn't mean that an individual applicant can look at the code and say, oh, I could use this utility system or that utility system. That is true. It doesn't provide that. Some examples could be certainly provided either here in the code. We could say including, but the following options, including but not limited to, and list some options. Or that could be provided in the applicant's guidance that would certainly be developed by staff if this is adopted by the council. With respect to, that's the high-level answer. With respect to this exact question about water, staff would expect that safe and adequate water connections would include certainly a plumbed, permitted, with a plumbing permit connection to the existing water line from the existing house, with all the required facilities, backflow prevention devices, et cetera. The permitted through a plumbing permit inspected by the building inspector, the normal fashion. It could also be something like and this is where I'm not a plumber, something like a semi-permanent coupling, where you have a permanent water line to the back, say, and you have a pad with the permanent pad built, permanent water line to the pad, and then an appropriate coupling that could then be coupled to the tiny house. That's, and I'm not going to, I can't provide an example of what that.
In a mobile home park, that's called full hookup.
Thank you.
Yes.
That would be another option. A hose? No. A hose is not an option. That would not be accepted.
Okay, okay. Then perhaps it would be better if we talked about plumbed and permitted, if we talked about for both water and sewer. For electrical, yes, I would readily concede that electrical service may be self-contained. We may have a tiny home that is completely powered by the solar panels that are on its roof. But this comes back to another one of those separate utility meters things. As we all know, if you start aggregating the use of water, you hit higher tiers and higher costs more quickly than if you have separately metered residential units. The same is true of electricity, and we've already covered the sewer. I would really like to see the separate utilities go away.
If I can add just one thing while you're
Yes, sir.
looking there. So I heard self-contained again, so we just wanted to circle back. So looking at the ADU ordinance, the word self-contained itself is not used, so that maybe.
It's not elsewhere in 10-2-1709.
So that might just be a word that we want to strike,
Okay.
because we define,
I
our,
think-
we give an explanation.
My
of what we
sense of it
mean.
is we will want to see that. Are there, at this point, any other questions for staff? All right, then I'd like to open the public hearing.
Can I
And-
make one
Yes, sir,
correction
of
real
course,
quick?
Of course.
Just below where we were looking, page 5 of 7, foundation requirements, subsection 2, should say if the movable tiny house does not have its wheels removed. And right now it says does have its wheels removed.
I'm sorry, the paragraph?
I2, foundation requirements,
I2.
subsection 2.
Oh, does not have its.
Yeah. Wait, does it? Actually, I'm reading it.
Does not have its wheels removed. If it does not have its wheels removed.
Oh. Yes, it should say not have its wheels removed.
Yeah, there was a
Does not.
yeah, the first one speaks to what the rules are if the wheels are removed. I2 is if the wheels are not removed,
Not
then they have
removed.
to be skirted. It was an error.
Then you have, if it does not have its wheels, then the wheels and the leveling support jacks must sit on a concrete, paved, or compacted gravel surface. Okay. I understand it anyway. Okay, any other questions for staff at this point? Then let's open the public hearing, and first up is Bill Miley. On deck is Kathy Richards.
I have to get my models.
Is that the one from the picture here?
Yeah, he has a live model.
A live demonstration? Yeah.
Good evening. For the record, my name is Bill Miley. I've lived on North Signal Street for many years. My 3-minute theme is there are better choices. Yesterday through Sherry, I gave each commissioner a longer version of my critique of this draft. As this proposal is to provide affordable housing for folks, I investigated other small housing choices. I believe we have 3 choices. Number 3, which is here, it's a model, is the tiny home RV. Number 2 is the small park home. And number 1 is the small manufactured home. The models I made show accurate size relationships. 1 inch equals 2.4 feet. And you take the roof off and you can see the livable features. I'll tell you more about that in a minute. Now for the draft. The draft ordinance for adding movable tiny homes to our residential zones will not be good for our city. This draft is full of holes. It will take zoning authority away from the Planning Commission and the City Council and give most of it to the current employee who happens to be our Director of Community Development. And we've seen a number of them over the last few years. This was pointed out very clearly at the last commission meeting by a local concerned citizen. This employee director will decide placement on property where it is, front, back, side. The draft ordinance doesn't say, and neither does the ADU. Style, if it conforms to nearby house designs, colors, type of human waste disposal, we kind of figured that out, and other utility hookups. Storage sheds and decks, there'll be lots of them on the outside because there are limited space in tiny homes, and people will be doing a lot of things outside affecting the ambience of the neighborhood. Okay. Now for the three options. The number 2 model is the small park home. It's delivered on wheels and then they're removed. It has up to 399 square feet with full height bedroom, bathroom, kitchen, and living room. They can be bought for a little $26,000 and up to $50,000, plus delivery and site placement. My model is one built by Athens Builders, Lindsay, California, for $39,000. The number 1 model is a small manufactured home, formerly called mobile home, with 560 square feet. It's delivered on wheels and then removed. My model is one built by Champion Builders of California with a full height, 2 bedrooms, a bath, kitchen, dining area, and living room. It can be purchased for $45,000 plus delivery and site setup, which is about $15,000 total. For a comparison, model number 3 is the tiny home RV, which has a full height first floor of 209 square feet and a loft of 81 with a 4-foot height limit. This is a model of the tumbleweed homes in Colorado. It can be purchased for starting at $62,000 plus delivery and site setup. And then, of course, they all have fees. I'm just finishing. So I request your commission reject this attempt to put small house-like recreation vehicles called movable tiny homes in our residential zones. Now that your commission and public know, and the public know about park homes, manufactured homes, they're livable, they're better structured, they price a lot less, I suggest we do this. Amend the draft ordinance by removing all reference to tiny homes. Replace it with park homes. Do we need to add manufactured homes? No, they're already in the ADU ordinance.
Thank you.
Last sentence. We need affordable housing which can be purchased at much lower cost, superior structural, livable, and economics. Cost less and get more. Let's promote the better homes. Thanks.
Thank you, Mr. Miley. Kathy Richards, you're up. And Vina Lusado, did I get that right? Vina Lusado? You're next up.
Good evening, Commissioners. I'm Kathleen Richards. I live in the city of Ojai. I own a home in an R1 residential zone, so I'm affected by this legislation. When I bought my house 21 years ago, I could have lived in a mobile home park. I could have lived in an RV park. I chose to live in an R1 zone with single-family homes because that was the kind of neighborhood I wanted to be in. I feel that this proposed change totally, radically differs from the concept of the neighborhood that I bought into. And I don't subscribe to the reasons that the ordinance gives for making this radical change to our zoning. I don't think that it's going to provide affordable housing. As long as we lack rent control, we will lack affordability. People can charge whatever they want. They can move out of their main house and live in the back and rent to lots of people in their regular house if they want to, which actually happened across the street from me. And it was a disaster for our neighborhood because you can't get the people out once they're in there and start doing things that are degrading the neighborhood. And I think if you talk to other people around town who have had a similar kind of experience, you'll find out that it's really, really hard to enforce what's going on in residences, in neighborhoods. One of the things that makes me really uncomfortable listening to your discussion here is that you have no idea, based on your questions, what this ordinance actually allows and disallows. You have to ask the city attorney mountains of questions about, well, would this be okay? Would that be okay? And Every time we get a new city attorney, you're going to get different answers. Every time we get a new planning director, you're going to get different answers. There will be no uniformity, no consistency, and there will be a huge opportunity for abuse. Right now, we don't even have a planning director. The assistant city manager is sitting in for the planning director. So this thing is wide open and way too loose. I don't think we should be having tiny homes in residential neighborhoods at all, but even if you feel compelled because you're being pushed by the city council to do this, I think if you give anything back to the city council with a recommendation to go forward, you should write a lot of detail into your proposed recommended ordinance, because this thing has no limits, basically. Depends on who's sitting in the chair of the director, what we're going to end up with in individual neighborhoods. In fact, in the proposed ordinance, the owner of the property doesn't even have to be the person who requests the permit. If you read this thing closely, there's all kinds of things like that in there. And it doesn't say what kind of permission the owner has to give to the applicant, saying, okay, you can apply for this. Those kinds of gaps in here are going to create enormous problems for monitoring and enforcement. All the questions that have been answered here tonight, every single one of them has something to do with, well, we're going to have to get somebody on board who knows about that, or we're going to have to find out, or we're going to have to, well, who's going to do all this finding out and investigating? We can't even monitor the standards we have now. Thank you.
Thank you. And in defense of the city and staff and tiny homes of whatever sort, I think we need to clarify here that the Ojai Municipal Code right now, Title 10, Section, or Chapter 2, Section 1709, which is about accessory dwelling units, says that you can have a stick-built accessory dwelling unit in your backyard by right. The city cannot say no if you want one. What we're talking about here is whether tiny homes on wheels or movable tiny homes should be included in that same category of residential unit for the purposes of the city. It is not, we do not currently have any rules, and we won't because of the state law. We will not have any rules that say you cannot build a tiny home in your backyard. What we're talking about here is, can you have a movable tiny home in your backyard? Any other type of accessory dwelling unit is already legal by state law. The city cannot even say no if you ask for a permit. By right, you can build one. Okay. Vina Lustado and Wendy Hilgers is on deck.
Good evening. First, I would like to thank the city staff for tackling this very complex and complicated ordinance for tiny homes.
Excuse me, ma'am, could you give us your name and address and tell us if you live in the city or not?
My name is Vina Lustado. I live in the east end of Ojai, so I'm living in the unincorporated area of Ojai.
Okay, thank you.
So I wanted to thank the city staff again for tackling this very complex problem. I also wanted to point out that movable tiny houses as ADUs are quickly being considered in many local jurisdictions. The city of Los Angeles and San Luis Obispo are considering more or less the same language that Ojai has before them. So is the county of Monterey, and they may beat everyone else to the punch as their ordinance seems likely to be on the county commissioner's agenda on August 10th. We also hear that San Jose is about to entertain the subject. It is just a matter of time which municipality will adapt the ordinance first. Our little town of Ojai has always been known as a beacon for innovation. I am proud to call this my home. This tiny home discussion has been before the council and the commission for the past 3 years. Since then, at least a handful of friends that I know have left Ojai because they simply cannot afford to live here. Many of them are a vital part of the community, forward-thinking artists and intellectuals who had much to offer, and this will only continue until our community is left with a monocultural landscape. One with big fancy houses and lots of wealthy people. No ethnic diversity, no teenagers or millennials, young families, none of them are able to raise their kids here. School enrollment will continue to dwindle. The housing crisis is part of a much bigger problem. It is deeply linked to sustainability and economic diversity. If we don't address it now, our city will look something like Montecito or Santa Barbara. We will lose the heart and the soul of Ojai. I also wanted to point out the discussion regarding the utilities. Since I have been living in a tiny home for many years now, I believe that the issue with the off-grid system is problematic. I believe that it should have permanent utility connections for water and sewer, and that perhaps electrical could be a separate item that could be powered by solar. But I do believe we need to have permanent connections for the utilities. And I also wanted to give some visuals for some of the questions I think that's been raised regarding quality and the visuals of ones that may look not so appealing with wheels. So I was told that it might be helpful to present these. This is my home, which you can see doesn't have any visuals of the wheels because it's disguised by the deck that's in front of it. So I will pass these around. And this is a recent installation with both my office and my home with even a larger deck that hides the wheels. And I wanted to address the question regarding the building code versus the ANSI. I think the confusion is that the IRC code, which is the Tiny House Appendix Q, addresses the items that are not typical for standard houses, like loft spaces that are typically much smaller, and the ceiling height is less than 6'8", obviously. This is about 4 or 5 feet to the peak, so you need to be able to provide some safety requirements for the clearance of that height for the ceiling, as well as how much do you clear for like the top plate height to the gable. So that's what that one building egress was requiring. And also issues regarding access to the loft. Right now, access with a ladder is not allowable within the UBC or CBC or CRC. So that's what the IRC appendix addresses. And again, this is
You had a picture there of your current residence, and you said the wheels are not visible. Is that legal under Ventura County rules right now?
well, as you know.
Looks to me a lot like a tiny home on wheels, and I'm just wondering, does that have a license plate on it?
Correct. It has a license plate. It's registered under the DMV.
Okay.
It's licensed as a travel trailer. So it has all the required DMV regulations for Department of Transportation.
Okay, okay,
And I'll just pass these around.
very good. Thank you, ma'am. Wendy, you're up.
Thank you. Wendy Hilgers, 704 Park Road, Ojai. Members of the American Tiny House Association have come to Ojai because they want to find a home for their recreational vehicles in Ojai. The only way they can get what they want is to make the citizens of Ojai give up their R1 zoning that protects our residential neighborhoods. Because these movable houses are considered recreational vehicles, built on a vehicle chassis and licensed by the DMV, the only places where they can reside legally are in RV parks or special occupancy parks. Ojai has neither. And because Ojai is just 4.3 square miles, the only place they can go and the place they want to go is into backyards throughout our residential neighborhoods. I don't think this is a good idea. This document gives unspoken benefits to RV advocates while diminishing the integrity and stability of our residential neighborhoods. Ojai's overall land use pattern is well established, and the R1 zone is at the core of our community as a traditional family one, not a transient one. There are too many kinds of movable homes, some built to standards, some not, and each backyard would present unique challenges. There will be many unintended consequences, but one thing is certain: Ojai will be changed forever. Please do not recommend this draft ordinance to the City Council. There are still too many questions. We haven't even heard them all. Thank you.
Thank you, Wendy. Lise Martin, and Bob Daddy up next.
Hi, my full name is Deborah Elise Martin Crawford. I live at 311 North Signal Street on the corner of Signal and Oak. I bought my cottage in 2001. It's under 750 square feet. It's a 1-bedroom, 1-bath. And I just came tonight to speak in favor of tiny houses. I know that it's a very complex issue. I want to thank each and every one of you for serving. It's truly a service all of you are providing. During the fire, I was blessed to live with my sister in a cottage in Ventura that she occupied for 11 years. And after that experience of having my home cleaned up from the ash and smoke, she then is now living with me without a second bedroom. Certainly we're in the position to do an ADU because I'm fortunate enough to have a 1-car garage. But I would love to have a tiny house for her on this property, and that's been a dream that we've had for over 3 years and been in touch with Vina and others. Susie Orman speaks about people first, finances second, and things third. I feel like that, like Paris and other amazing cities in this world, people are living together in closer quarters as families. There are ways for each of us to make our way with this, and I believe that tiny houses, even without being on a stable foundation, I'm not particularly for more concrete in Ojai. I would love to have the ground, the trees, the landscape, and all the greenery enhanced by not having to put them on a foundation of that sort, but rather to have them live lightly so that if someone's blessed to have another parcel locally and can take that little tiny house there and create their dream, you know, it'd be a wonderful thing for all of us to see all of our family and loved ones cared for and find their own way here too. Thank you.
Thank you, ma'am. Bob Daddy and Souza Francina up next.
Good evening. I live in Ojai. I live in the block behind Mr. Quillisi. You know, I wish you folks would take this in a different direction. Before you make a recommendation to council, you have around 20 questions. You're only going to get as good answers as you have questions, and we've got some really pathetic questions. Fire department certainly should weigh in on this loft issue. That water quality should give you definite determination along with the environmental health and event or resource on what we're going to do about self-containment. When you brought up the position of hookups, of course utility companies won't allow for another meter. And the reason is under this proposal, this is no different than having a boat. Same thing, have a plate, you got a boat. They're not going to hook up, they're not going to wire gas, electricity, and other things to the boat. There are ways to make this thing work, but I think we're so far off base here. We have accommodations for horses. I got a 56,000 square foot lot. I can have 3 horses. We don't have an accommodation for travel trailers or mobile homes by design. And that was designed for a lot of years ago. When I got here a few decades ago, I happened to be going down Lower Montgomery, and I wondered what that area was just south of the art. And it was explained to me I apologize ahead of time, but it was explained to me as kind of an artsy, nitwit, kind of beatnik area of housing of tiny, almost shacks. And it was accommodated. I think what we need to do is the Planning Commission, we'd be better looking at zoning, inclusion, and come up with some different zoning areas where we can have some very small I don't know what the verbiage is. I don't want to say trailer parks. But we have them all over the unincorporated area. We have a number of them in Miners Oaks. We have them in Miramonte. We have them over by Rite Aid. We have enough land in town, and we can include land from out of town. We've got some prime areas that will work. And I think what we need to do is we need to have a special zone. And that takes care of the hookup, the permanent utilities. It takes care of the electricity where you can plug in and plug out, where you've got the waste, where you can take care of all of these issues. And we make these things enormous. They're not enormous. We've got smart people. We just need to take a look at the zoning, and I think we can find a place to zone, and I think we can find a place to accommodate. Thank you.
Okay. Thank you, sir. Sousa?
Sousa Francina, 208 North Ventura Street. I was at home watching the live stream and I found it riveting. And then when I heard you make the point that in Fresno that no permits had been granted, I wanted to just make the comment. I asked Dan Fitzpatrick about this. We had a chat. Why they're legal. Dan Fitzpatrick, he spoke before the Planning Commission. He's a tiny house advocate. He's known nationwide. He knows all the legalese. Anyway, he said because housing there is so inexpensive that no one has pursued a permit. So, both rentals, and I looked it up, you can buy beautiful house and a rental for what used to be in Ojai, maybe even in 1980, going way back how it used to be. So that's really the bottom line. So what else was I going to say? Oh, I want you to drive by my house, 208 North Ventura Street on the right. You'll see my little white house with a white picket fence. And on the other side, you're going to see the most hugest travel trailer, probably 4 times the size of a tiny house. I have to look at it every single day. We have a shared driveway, and evidently that's legal. Okay? The tiny home that I'm most familiar with, and I've spent some time in, is Venus House, and that was what we had envisioned originally, something of the highest standard that looks absolutely beautiful. And I think legally that's all I'm allowed to say. Thank you.
Before
It is a
you-
legislative matter. Because it's a legislative matter, the council members are free to make public statements, but you can also refrain and wait till the council meeting.
Okay. Well, I think I'll leave it like that. I think, I was impressed by the discussion that I saw prior to coming, and I really appreciate the intelligent way that you're looking at this.
Before you leave the lectern, is there someone living permanently in that travel trailer?
No, they use it for travel. Not that I know of. If they do, they sneak in and out at night. But I haven't seen that. And I know that during the fire, the whole family left with the travel trailer. Yeah.
Okay.
Yeah.
Thank you.
But I'm just making the point that these giant, relatively ugly things are evidently legal. So, I guess that my point
Because they're
is.
trailers, they're not houses.
Yeah, and my point is that there's really no comparison between a high-quality, tiny home, whether it's on a foundation or on wheels. There's no comparing it to unless I like that Bill Miley brought up the point about other housing options. I think we should be looking at all of them. But I also want to make the point that I think the fear that there's going to be thousands of these in people's backyard is completely unfounded. I think Lise is very typical of the kind of person, she wants it for her sister so that she doesn't have to, share a small home. And the other probably dozens of speakers that we had here are typical of people. They're not looking at this as a transient situation. So it's unfortunate that they're called, what are they called? Movable homes. Because the intention is not, anyone can vet the person that the intention is for it to be as permanent a resident as any rental. I've been and I'm a renter. My last rental was 12 years, and my current lease is 5 years. I'm going to extend it. The issue of transiency is the same as it would be for any rental that's month to month, and the issue of permanence can be addressed with a lease.
Okay?
I think that's all I want to say right now.
Thank
Thank
you.
you very much.
Thank you. Is there anyone else here wishing to speak on this topic?
I would like to, sir.
Okay?
Say again?
How's the grant coming?
I'm not familiar with your name. Mistaken identity?
Yeah.
I have no idea. Hi, my name is Bradley Smith. I live at 306 South Blanche Street.
Just right around the corner here.
Yes, sir. If you look out the window, you can see my house. That's right. I've been here before. I'd like to speak in opposition to this. I think this is a solution looking for a problem, and there is no problem. The problem doesn't exist. There are means for people to have a second dwelling if they want in their backyard. I totally agree with what Mr. Daddy said about having a zone for these type of things. Call them what you will. You're being asked to shoehorn something that doesn't fit into something that has been in existence for many years. You want to put a hybrid into something that is not a hybrid. You're trying to accommodate these people into a residential zone that's been in existence with its own rules, its own building codes, and now we're talking antsy and, well, yeah, we can do this, but we can't do that, but well, why not make a zone where you can do these things and not shoehorn it into a residential zone? I believe in being accommodating. I think every time one of you brought up a question, well, we have to talk to the attorney, and well, yeah, it could go this way or it could go that way, and there's this and there's that. There's no real definite answers. But when you look to the building department and the building code that's existing for an R1 zone, it's all there. You don't have to reinvent the wheel. The wheel's been invented many years ago. Why reinvent the wheel? That's all. Thank you very much.
Thank you, sir. And in Mr. Summers' defense, my son is an attorney, and his standard answer, if you ask him a question about something in the legal realm, is it depends. So, thank you, sir.
Hi, my name's Nick Hyde-Smith. I live on Shady Lane, 209 Shady Lane.
Okay.
Ojai. My thought is on the property taxes and regarding the wheels removal, I can't see that as ever being a plausible thing that would ever happen. I can't see that. Who's going to remove the wheels and call up Ventura County and ask to be assessed for more property taxes and more water bonds? It's not going to ever happen. They're going to cover up the wheels like Vena's got on hers. I feel like the whole RENA number thing to me was confusing. It was somewhat of a smokescreen to get this thing pushed through. I was confused totally at the council meetings, and it just didn't make sense to me that it was required and then it wasn't required. Now tiny houses don't satisfy the numbers. I don't know about any of that. And I agree we should have a designated area if we want to try it out. Okay.
Thank you, sir. Anyone else wishing to speak on this topic? All right, then we're going to close the public hearing and bring it back to the commission. Discussion. We've asked a lot of questions already and gotten some answers. And I would ask if there is anything else that you wish to discuss at this point, or ask additional questions of staff, or opine on the various topics that we have covered in the ordinance or the ordinance itself. Kathy, go ahead.
Yeah, I was going to suggest, there were certain items that we all seem to discuss and have questions about.
Yep.
And some of those were also ones that were brought up by members of the public, and I think they're all good. And so I'm just wondering if we want to just kind of go through, I mean, I have a list, and I'm sure there might be some more that I missed, but we might want to go through those and then discuss each item and see where we agree or don't agree or come to consensus.
That's fine. Go ahead. Why don't you
Suggestion?
start at the top of
All
your
right.
list?
And these aren't necessarily in particular order, because I started taking some notes early on. But for instance, I'm going to start with the utility hookup. And I mentioned this at the beginning of when we were having our staff report and asking questions. In my opinion, I believe that we should follow the same standards that any ADU would have. Keeps it completely simple. If down the road something and then change, the code changes where you could, be off grid, whatever that means, then that would be across the board for all ADUs. It wouldn't separate out movable tiny homes. So I'm throwing it out, and then I would propose that we would standardize the utility hookups to match ADUs.
And along that same line, I think I recall having mentioned it, but I don't recall what the answer was from staff. Does the Ojai Municipal Code 10-2.808 that requires underground, 10-2.808, that requires underground utilities for all new structures, does that apply to tiny homes on wheels? Excuse me, to movable tiny homes?
That's a good question.
I think they are structures. I think they're residential structures intended to be. And so my question would be, does a parcel owner then have to provide underground utilities of whatever sort are needed by the movable tiny home to be compliant here? And how will that be enforced, and how will it be inspected?
Well, it's the same as what, they're going to answer the questions too,
Right.
but being in the building industry, there's a very simple standard to that utility hookup. I mean, there's the depth of trenches for
Right.
gas lines, there's for water, there's all kinds of codes that are already written for that.
Okay.
So when Kathleen suggested that we just adapt the same conditions as are already established for ADUs,
For other ADUs?
then that pretty much covers it.
Okay.
There's already
and-
codes there to do
And then
that.
10-2.808 does in fact apply to a proposed movable tiny home in a yard somewhere.
So we're confirming, we actually don't believe that section applies to ADUs, but we are confirming that now by trying to look up the code quickly.
Oh, okay.
But I was going to suggest the same thing, which is making them comparable to the ADU and treated the same way, which we will have an answer on
Okay.
what that is exactly.
Should we wait or go on?
Please,
Okay.
we'll come back to an answer on that one then.
So the next item was, and this had to do with ANSI as compared to the California Building Code, and specifically for the emergency exit and the loft. So that was another hot item. And do we just go with the ANSI code? Or do we go with the ANSI and have this one portion?
With one cutout for the California Building
Right,
Code.
Right, and that's assuming, we definitely would go with the third-party certification. If the ANSI part was there, then if we decided to have that one section with the building code, how would that work? Does that make sense?
Is there any provision for that emergency exit in the International Residential Code? I don't.
Yeah,
I
it's
thought one of the
it's
speakers said it
egress,
was-
it's egress, it's an egress code, and it's very basic.
Appendix
know,
Q or something somewhere.
Yeah, and I pretty much, I agree with the assertion that that's required in this particular situation. And I like the idea that we could take some California codes and apply them in this case. I wasn't aware that legally we could do that at some point, because it does cover, and I think in the future as well, if this were to go forward, it does give us additional items to add to that if those came up. So I don't have a problem with it anymore. My question was the legality of it, of saying one thing that we're not going to require we're gonna require an ANSI certification, and, oh, by the way, we're also gonna require you to adhere to this California Building Code.
R310, yeah.
So that, but I think that would need to be clarified in the permit application process.
We, as far as the undergrounding of utilities, that section does apply to ADUs currently. And so if you made them, if you made this section comparable, it would apply.
Okay,
And that's further restated in 10-2-1709 itself, which reads in part, quote, "All public utility services to the accessory dwelling unit shall be underground."
okay, good. Go ahead, Kathy.
So any other, I would say, is there any other comments?
Um,
I'm in agreement with Chester that it's something worth exploring, having the combination, but
I think we have a duty to public safety
Oh, I
to,
do
to
too.
make those,
Right.
make both of those conditions
Mhm.
part of a permit process. I'm wondering if anyone here knows if a movable tiny home built to the ANSI standards also meets that portion of the California Building Code. Just,
It
my
does,
sense of it is it probably doesn't.
it does
but
not, it does not.
It does not.
Just by itself.
And
But-
so
but they
we're gonna have two different inspections or certifications.
Well, I see it more,
Qualified.
I see it simpler than that, because there's already going to be an inspection from our city inspector. They're gonna inspect the utility hookup, they're gonna inspect, the location, the setbacks. Well,
That would be
that's,
the building
that's
official
the
or
building
designee,
official
right,
there.
yep.
But the utility hookups for sure. And of course, when they submit the plan, the plan will have to show, that their tiny home has that egress and has those types of features that we're calling out in the California Building Code.
And
It's
so-
it's a fairly simple process. It's not really
Yes,
that
I
complicated.
may have maybe added to confusion earlier when I said that there would be a separate third-party inspector for the ANSI standards. But yeah, there are other portions of this process that would require the building official or his designee to inspect.
Okay, okay, well, go ahead, it'll come back to me,
Okay.
sorry.
It's
The other one was about the duration.
and city inspection.
Here, members of the public.
Is your voice on it? Is your?
Oh, sorry, it wasn't. The next item I had was about the duration. In other words, how long would the tiny home be required, the
Jay.
minimum requirement to be on the site? And that gets back to this whole thing about, a transient, and we don't want people moving in and out. And I know in our last meeting that we had, I brought up, what if it was required, somewhere between 2 to 5 years, rather than just the 12 months? And I bring that up again. I'm not necessarily opposed to it for a couple different reasons. I believe, if a property owner is going to go to the extent of having a movable tiny home, going through the utility hookup, having a pad, whether it's gravel or concrete or however they decide to do it, there's some, funds that are going to be invested.
Right.
And if you are renting it out or leasing it out, you want permanency. You don't want to have a vacancy, most likely. So, there's that drive to have somebody stay there longer. So I wouldn't be opposed to increasing it from 1 year.
But this duration is
Mm-hmm.
talking about how long the movable tiny home stays in the backyard.
No, it talks about how often you can pull a permit.
Well,
for
there's
one.
that
And,
too.
Yeah, because once
Right.
it's removed from the property, it will require another permit to be able to put an additional tiny home on there. And that duration is 1 year right now, which I believe is too short as well.
Right.
I think if you go to more of I think a 3-year is a
So-
fine balance there.
Right.
It's a long enough time period to settle in.
Yeah, Bobby.
One of the, I forget because I looked at it so long ago, but one of the places, somewheres in the south, that was on the video that you were on, the way they dealt with that issue was, yeah, he's a star. The way they dealt with that issue was by requiring a porch or a deck on at least 2 sides of the tiny home. And what that does is it nicely allows it to meet the ground, and it makes it look like it belongs. And I think that rather than dictating 2 years or 4 years or whatever it is, that's a nicer way to do it, because that requires a certain amount of permanence. Two, it's not that easy to move it, and you'd have to take it apart, put it back together again. And I think that might be a nicer way to do that.
You'd have to consider that movable tiny homes come in various sizes and shapes.
Of course.
That would dictate changes to those two sides of deck as well.
That too, that too. And I have some issues too, so finish.
Well, I think I'd like to add to that, though. How would we then go about it? I think that we can only do a recommendation there, and I think we should add that, if we were to move forward, we should add that to the conditions. Well, the decking, both the years, but the decking would be a recommendation that, you know, I don't know if it could be a
Design guide, part of the design guidelines?
it could be a design guideline.
I mean, it could be an option
Because
for the
most of them I
skirting.
know
Yeah.
prefer to have the deck because, again, tiny homes are small, and in California, we get to live outside a lot.
And turn around, yeah.
Yeah, and so we could require a certain minimum size deck permanently affixed to the tiny home. And
Are we now getting into building standards, or
yeah,
is
but
this?
that's, no, anything less than 18 inches up off the ground, I don't believe needs a permit for that, right?
Right. And it doesn't have to be attached to it. Can it
And
be
it-
freestanding? I mean,
Yes.
Sure.
it doesn't have to be.
Well, but to be attached, that's.
But it-
Then it makes it permanent, more
Yes,
permanent.
again, and that's not a big deal. You're talking about a ledger,
Right, right.
affixed, which
If
is,
it's less than 18 inches off the ground, then you can build it by right, you don't need a
Yes.
permit.
that's correct.
Okay, interesting. Please,
Next.
go ahead.
All right, I am in 100% agreement that there's a third-party certification.
Yeah, ANSI.
And
the
at
ANSI.
this point, there's two different certifications. One
Right.
to ANSI,
And then the
one to
building,
CBC R310.
Which we handle within the city.
which we handle within the
Yeah.
city, right, with the
Right.
building. So, yeah,
Okay.
so I propose or agree with that. The other item was the address, and I do agree that it should be given an address with the B, however they decided to do it.
Again, it should be treated just like an ADU.
It should be
'cause
treated
it
just
is
like an ADU.
Yeah. I'm in agreement.
Right. The other one, that you could add solar, and this gets back to that mechanical description of a mechanical equipment.
I
Just like
think,
any
yeah.
other
Yeah,
ADU.
yeah, yeah.
Clarification of the wording to make
Right.
it clear that the mechanical equipment is not including solar panels, which would almost have to be on the
Right.
roof. Yeah.
Exactly, okay. The property tax is out of our purview, but I understand the questions and issues that people have brought up. I would also do one of two things, and this has to do with that all-weather pedestrian path. I would either strike it completely or make that be inclusive for all ADUs. In other words, we're isolating,
Again, we're
Right.
pushing the line here. Most
Pushing the line.
practical people are going to
Exactly.
make a path to their home. I
Right.
mean, it's.
whether it's.
Yeah,
it's-
the idea of us having to
Whatever the-
state that as a requirement,
I would strike.
it's just over-regulating to me.
The other one, and I know this just came up in the discussion too, and I believe staff had mentioned this, and I'm sorry I didn't write down what page or item, but it was about striking self-contained, and that had to get back to the utilities, I believe. Yes.
Yes.
Yeah, it was
Attachment
utilities.
A, page 407, the fourth section from the top, subsection F.
What was that page again? Pardon me?
Attachment A, page 4 of 7,
Okay, thank you.
subsection F.
Sub F. Okay. It sounds like I'm almost making, going a little too far.
Take your time.
Yeah. Also, on page 5 of 7 on attachment A, we were going to add the word not.
Right?
And so if we're all in
It's in
agreement,
I sub
I sub I.
Line 1, right.
And then a member of the public brought this up, and I thought it was a very, a good question. And it was, and maybe it's something we shouldn't be talking about, but I think something worth bringing up. And that was the arrangement between, like, a property owner could actually purchase or build a tiny house on their property and put it in and then rent or lease it out. On the other hand, it allows for a property owner to align with a second party that may have a tiny home and make an agreement, and they bring that in. And I guess the question is, what is there a standard arrangement, or does that matter?
To me, it has to be with the owner of the property.
well,
It cannot be, you cannot be making,
Okay.
what is,
Yeah, there's a section 3C on page 4 of 7
Mm-hmm.
that requires that the applicant be the property owner or have sufficient written permission from the property owner.
Okay, so that's good then.
Could you clarify sufficient written permission from the property owner? Is this a simple?
legal
A simple
agreement?
letter
Yep.
that says, I'm the parcel owner, and I think it's fine if Joe Dokes
Yeah, we would have
puts a
the,
movable tiny home on my property?
What we would require is a signature on the application or a letter that asserted I as property owner on the deed of 123 Main Street approve the application. The key is that the city's not going to regulate the private arrangements between the property owner and the tiny house owner.
Should not.
Should not, rather. That's, again, a policy choice. Staff recommends that the city not. They can come to whatever arrangement they want to do, whether a handshake to a written notarized lease. What we need confirmation of, though, is that the property owner consents to the land use permit application, whether they are the applicant or they provide written proof thereof.
Okay. And then before a permit, would the permit be issued to the property owner, or would it be issued to this third party who now has permission from the property owner to locate a movable tiny home on the parcel?
Property owner, well, but we worded this as the applicant to the other guy, too. We'd make the indemnity sign by both. Yeah, let's make that run of the land.
yeah, we would have it issued to the property owner, and it
And
would,
perhaps, and the tiny house owner, too.
but it would be a and, not an or. So it'd be the property owner, possibly, and the applicant if there's another applicant besides the property owner, but the property owner would get the approval.
Okay, that would certainly fit better with the philosophy of if the third party removes the movable tiny home, then a new permit is required. And that would involve the property owner and a new third party. And it also is more consistent with the Casitas water bond thing, and that says the taxes attach to the parcel. They don't attach to the movable tiny home or any other structure. And that's maybe a word of caution for parcel owners. If you have someone, if you make an agreement with a third party to put a movable tiny home on your property, and you underground the utilities, and you provide the all-weather path and the pad for putting the structure in there, then you're going to incur that tax, and you're going to have to jump through some hoops to get it undone if that third party picks up and moves to Oregon because there's more rain there, as we heard at a city council meeting once long ago. Please, go ahead.
The other one I wanted to bring up, and we didn't get into it too much tonight, but I know in the past, and I know it's something we actually brought up from the get-go when we first brought up the topic of movable tiny homes, and that was design guidelines. And I know the question keeps coming up, what are they going to look like? It's going to ruin our neighborhoods. But there are clear, and then there's also some leeway to these design guidelines. And basically, we're saying we're following the ADU design guidelines so that the materials are compatible with an existing neighborhood or
It
the
should
property.
look something like a stick-built house.
Exactly, so we're not bringing something in with, like an Airstream with, bright silver metal siding, or something that looks like a typical RV siding or a mobile home.
Right.
siding. So I want, that's, I think, be really clear on that. And then the other thing is, and this kind of gets back to your question or recommendation about putting a deck, because if the tiny home stays on the wheels, we're recommending some sort of skirting. So essentially, it's going to look like a tiny house that was built on a foundation.
Yeah.
And there's a real good chance you could look at one and not even know, unless you went in there and started taking things apart.
Right.
So if that's built into it and the design guidelines that it has to look like any other ADU,
Right. And it's in the rear yard.
and it's in the rear yard, it follows all of the setbacks just like any other ADU would have to do. Essentially, it gets back to, once again, what we've discussed before, that the big difference is the property tax, which we can't go into here because that's something we can't
And the water
decide
flow.
on.
And the water bond and the RENA.
Well, the RENA numbers, but if our goal is,
Numbers are still
That's being-
that's in process.
That's
yeah,
not
that's in
something we
process.
can decide here.
and we can't decide on, and then the other thing is, I believe the reason this was originally brought up, I believe I was the one, you and I, who brought this up, was we were trying to look at ways to add additional types of housing. And then, of course, then the thing with the RENA numbers came up, and yes, we do want to try to meet our RENA numbers, but is that our ultimate goal, or is it the ultimate goal to get some alternative types of housing? In my opinion, it's the alternative types of housing. The RENA numbers would be a bonus. So that's an issue, the property tax, which we can't do anything about. The foundation, I mean, that's it, and then the ANSI standards. I think those are like the four things that would say this is different from a regular ADU. And I'm trying to think, I think that's pretty much all I had on there.
Okay, I did
You
have
probably,
one.
there's probably some more, yeah.
One question for staff. We talked here about setbacks and all the usual things that apply to other ADUs. And my question would be for the city attorney, do those standards fall somewhere already in 10-2-1709? Or are they covered by the same requirements elsewhere in the code? Or do they need to be stated in here?
Section 10.2.1709 has a lengthy table, Table A, which specifies a series of design and, not design, rather, setback, height.
Okay, the land use and,
The kind of the typical land use standards are specified there. This is intended at page 4 of 7, subsection 4B, taps into that table, and it sets these as the same
very good,
rules
very
for
good.
new detached ADUs. Which,
standards incorporated by reference.
well, yeah, and recall that this subsection is meant to be another subsection at the end of 10.2.1709.
Right.
So it's not so much incorporated reference as it's saying, see above. And on that point, if the commission wished to, as suggested by the vice chair, the requirement that these be placed in the rear yard could be added. Fresno, I believe, has that. That's not in the present draft. The requirement that they be consistent in design or compatible in design with the primary residence could also be added. That's not in the present draft. Those are both policy choices.
We may not want to go to that one because we decided on the ADUs that if it's in the rear yard, it necessarily doesn't have to be. If it's attached, that's where that
That's
comes in. Then
right.
we want it to be looking at appearance to the existing structure. So I'd like it to stay the same for both. So again, applying the guidelines for a regular ADU should be applied, because I believe that's how we wrote in the ADU ordinance.
Yeah, that's correct.
Yes,
For an
yeah.
ADU, attached has to match the house's design.
But unattached can
detached
be.
does not.
Yes, so I'd like to maintain that because I think it's practical.
Yeah, I do
Most
too.
people will adhere to that.
Compatible with the community and the neighborhood or
Well, it's,
something, but not
yeah.
identical to the primary structure.
Exactly,
Yeah.
yeah. And that's how it's already written in our ADU ordinance.
Right.
So
Well, this is, I guess, a question that I have then. There are apparently some parts of 10-2-1709, the ADU ordinance, that apply here and don't have to be restated here. Although this reference to Table A is obviously an explicit call-out. Are there any other portions of 10-2-1709 that apply here to subsection L that are not stated, but they do apply because they're in 10-1709? And then as a corollary to that, are there any portions of this proposed subsection L that are going to apply to other ADUs because they're explicitly stated in here?
Nothing in this subsection L would apply to other ADUs. This isn't to answer the second question.
Okay.
This only sets the rules for movable tiny houses that meet this definition, that meet these standards. The requirements of this subsection vary slightly the requirements of the regular 10-2-1709 as I think specified. In particular, the utility point, the lack of a permanent foundation, the lack of California Building Code compliance, the
different building standard.
the different building standards, the smaller maximum size, the pedestrian access, which I guess we're discussing to maybe change that. Those points are all, and of course the ANSI point is different. That is provided in the beginning of subsection L on page 3 of 7 that states that they have to meet the standards in this subsection and the applicable requirements in table A, the main portion of 10-2-1709. So 10-2-1709 sets your floor, and then you've got to adjust it further as specified in this subsection L. And in particular, that calls out that the requirements of subsection D1C and D1D of 10-2-1709 do not apply. D1C, to not force you to have the code memorized, D1C provides that mobile homes and travel trailers, and mobile home is a defined term, meaning state-certified mobile homes, do not qualify as second units.
Okay, so
This varies that.
the words "this section" means 10-2-1709.
Correct.
And this is subsection L.
Correct. Every reference to this section is 10-2-1709. Every reference to this subsection is this subsection L. The second requirement is 10-2-1709 D1D, that this varies, is the building code. ADUs must meet the building code, the minimum standards of Title 24 that applied at the time the ADU's building permit was issued, or it was permitted by the director, whichever is most recent. That building code requirement for regular ADUs does not apply here, provided they meet ANSI standards. Those are the two key things that are varied.
Okay, that first paragraph of subsection L then, at the moment, says the ANSI standards. It does not say the California Building Code standards, R310.
Correct, that's cited in that could be added there, but it's also picked up if you read on to that subsection K, because that first sentence you're referring to, the requirement of subsection D1D does not apply to the extent inconsistent with the standards of the subsection
Oh, right,
and the
it has
ANSI
building
rules.
code there.
But it could be made clear because that
Yeah,
cross-reference is perhaps,
I think it would be clearer.
yeah, we can do that. The cross-references get stacked on stacked on stacked.
Yeah, I hate to see things that may appear to be internally inconsistent by omission. That confuses people in general.
Certainly, we can clarify.
Okay? Bobby, go ahead.
This is another one of those instances that just speak to me of the need for a design review committee, I would call it. I don't want to make it like some big formal thing that requires 22 extra permits, but I feel that we have, and it's the next topic, which could go on for hours, so many design guidelines. There's so many pages. They're so complex. They're so specific, and yet they're so vague. And I feel like one of my main concerns about these tiny units is that some of them are just such a hodgepodge. We want them to look nice. I understand that it's so expensive and complicated to build something from scratch. And I think that this is a nice alternative, along with, certain good manufactured houses, in terms of doing housing in a less odious way. My fear every time we add all these like stipulations to them is we're going to wind up in the same place. But theoretically, if the box is already made and standardized, that is some kind of a savings. It would be nice if there were 12 of them and were pre-approved that, could just go through. But again, I think it's too much responsibility to place on one person, on the community development director, who's not even here. And I think that is problematic. I think the community development director has a lot of work to do in addition to like going through this and, they'll just go, oh yeah, I guess that looks okay. And again, I think that it's really critically important that we establish a design review committee, whether it's part of the planning commission or an offshoot of that. I think there's so many instances where that's been necessary, where somebody can look at something and really understand what they're looking at and make a judgment about it.
I'd like to comment on that if I could.
Please.
That's good in theory, but let's talk about what's the law of the land regarding ADUs. That's not required for an ADU.
It should be.
But it isn't. But but again.
It should be required for every project that goes through this town.
Well, not necessarily. Most people wouldn't go for that. Okay, we have some guidelines, and we apply those guidelines. If you go for a residential permit and you go for an ADU permit, you don't have to submit to that kind of scrutiny.
That's different, but we do have design review permits, and
Only for certain specific things. For residential, it's only 2-story, right?
Yes, but because of the fact that there is such a confusion or a feeling of concern about the fact that these are basically trailers, which they are, I think this is an instance where it would be nice, it would be good if there was somebody looking at it. What I'm saying is that, yes, we've said the community development director should look at it.
Just like they look at an ADU that comes across as to be permitted, so I went and I applied for a permit. But, yeah, they have to look at my plans and look at my ADU, whether it's permanent or not. So, yeah, in some ways, we're always trusting our staff to do their job, and that's the nature of what it is. I don't think it's
That's
that
true, but
far.
there are other places
but
that
I-
have
I do
design
be-
review
I-
committees, and I think it's an important function.
It's true. Some places have a separate architectural review committee.
Well, not for ADUs, because it's illegal to do, so I'm cautious to apply a standard that's not being applied to another. At the same time, let me validate what you're saying. I think the concern that they're going to be some kind of offshoot of a tiny home. Most of us know what a tiny home looks like. I mean,
I think that I've seen from one extreme to the other, and some of
But
them I would
still.
hate to have to look at from the back of my house.
But that would be true.
Mr. Chairman, I was going to interject that, as Mr. Vega pointed out earlier, it's our intention to put together a brochure or guidelines that would apply to the tiny homes that could address the things like skirting and the decks that you've talked about this evening, and give examples of tiny homes, talk about compatibility and consistency. So it isn't go to the level of an architectural review, but it certainly gives
guidelines.
it
Sure,
communicates-
I'm
it communi-
definitely open to guidelines.
It communicates
but-
the intent.
But to go to you're suggesting, a design review for.
No, I'm not suggesting a design review. I'm just saying maybe more than one person should look at it.
Volunteer?
Yeah, I'll look at them. I'd be happy to.
Again, you have to have broad, because you know how design is very, people's taste. I've seen everything across the board.
We're not talking about taste, we're talking about quality.
No, we are talking about taste. I tell you, I built enough homes in this valley here to know that some people completely hate some things and some people love them. It's a very subjective thing.
And some of them are horribly built and some aren't.
Well, but
Whether
horribly
you like
built-
it or not, it's not a matter of taste. This is the question that always comes up when design comes up. And my feeling is this: if design is all about taste, we might as well close every design school we have in this country. There are standards of proportion and use of materials, and it doesn't matter what the material is. It can be used nicely, it can be used not nicely. And if you've gone to design school, there are a whole process of things that you learn about.
I do. I went to
light,
architecture
color.
school.
I know you
5
did.
years. So
I know you did.
And I built hundreds of homes in this
I know
valley.
you did, and
So,
but you know, we've been through processes on this board about this issue, and you get a lot of people who look at things who don't really understand what they're going to be like in 3 dimensions, and that's all I'm saying.
yeah, but how do you apply, again, I understand what Matt is suggesting over there. I think if you have I think we're not that far off of what we're saying here.
These are design guidelines. We have like 1,700 pages of them, and we had big fights over this.
Mhm.
And I think we weren't always happy about how they came out. And part of the problem was people looking at it, making comments about things that weren't really there because they couldn't understand.
Well, there's a difference between a design guideline for the downtown area of Ojai than a ADU that's in the backyard of someone's property. There's a very difference. There's a big difference. And one of them, we don't have a lot of jurisdiction on. I mean, look at Bill Miley's photographs. Some of these you wouldn't even, you could just go ahead and put a manufactured home there by right, okay?
I don't know if a manufactured home is legal as an ADU or
Little
not.
ranch?
No.
Yeah.
A state licensed mobile home.
Not mobile,
is-
manufactured home, I said, manufactured.
Manufactured home is not a term of art in the law. The legal term is mobile home. Those are permitted as primary units in any R1 zone, any residential zone, if they meet certain state minimums. That's the classic single or double or triple wide. Those are allowed, but not as ADUs, not in the city.
So what I'm
Aren't
saying
they
is. that-
allowed as primary units in the city?
If it meets
No,
certain state standards,
all
yes.
I'm hoping is that, and it's not going to happen, but I have to say it because I always say these things, is that I would like to see a little bit better standard of design consistently in this town, and I just don't think we have it. I think we have so many regulations, and just like that, they don't necessarily make a good product. It might be safe, it might be livable, but doesn't help the quality of our town or how it feels, and we're kind of a hodgepodge. And I can't help but hope and wish that we could do better.
Mr. Merck, you have been uncharacteristically silent.
Oh, I don't know about
I don't mean that you're
uncharacteristically.
talkative, but I haven't heard anything from you this evening.
There's a reason for that. I think I agree with Mr. Smith's comment that this is a solution in search of a problem. I see no validity in the concept of tiny homes on wheels in the city. And I am appalled that this body has devoted so many hours of staff and commission's time to discussing the issue. I think it's a complete waste of our time. And, if you have a tiny home and you put it on a foundation and you connect it up to utilities, you have an accessory dwelling unit. And if it meets all the setback requirements and lot coverage requirements, good luck to you. That's great. But this whole discussion about homes on wheels that can be there or not be there, and maybe they're hooked up and maybe they're not hooked up, and who cares what they look like, I just think it's completely invalid. And I I don't know why we're even discussing it. So I haven't contributed to the discussion because I think it's an invalid
I
discussion.
think you've made your position clear. Thank
Yeah.
you. Any other comments from the commissioners? I have to say, in large part, I lean the same way that you do. At the same time, if we are going to do what City Council asked, and that is that we consider this proposed ordinance in detail, it is my personal feeling that we have raised a lot of issues, some of which have been and can be answered, and others which have not been and may or may not be answerable, including a brochure with guidelines. I would not feel comfortable recommending anything to the City Council without seeing what, unless we just decide by outright vote here to recommend that this ordinance not be adopted in any form whatsoever, and that is certainly one of our choices. But unless that is the case, I do not feel comfortable right now recommending anything to City Council without seeing a lot of our questions answered, and answered in writing so that we can go back and review it in the same detail and with the same care that we have what's in front of us today. Yes, sir.
I wanted to clarify, I did misspeak, with apologies to Commissioner Jagiello. The state-defined code in Health and Safety Code Section 18007 is manufactured home. I apologize.
It is what?
Manufactured home.
Manufactured.
The colloquial term is mobile home. The state code term is manufactured home. I'd flip those in my head. Yeah, the rule there is a manufactured home that meets certain state standards, constructed after 1976, 320 or more square feet, and connected to all required utilities, can be permitted in any single-family zone as a primary unit, but not under the city's code as an accessory dwelling unit. And that's a state-defined manufactured home.
Yeah, that little lot at the corner of Montgomery and Franklin that the city owns right now, the city could decide to put a double wide on that property.
No.
It's a manufactured
I'm not going to
home.
opine right now on one particular lot without analyzing it further.
Okay, it's currently an empty lot. It's in a residential zone.
But in any R1 zone, that can be done, yes.
Okay.
A manufactured.
Yeah.
He's talking about manufactured, not mobile.
And these are also require state certified.
He said manufactured is the
That's the code term, and it's
term of art in the state code?
yeah, Health and Safety Code Section 18007.
Okay.
Well, there is one right around the corner for me on Grand.
Yeah, I was just going to bring that up. You basically,
But it's legal.
John, do you remember that?
That's exactly what,
I
I
think
mean,
it
that's
was-
exactly what I'm talking about.
It was 2010 or 11-ish. There
house
was,
burned
the
down,
house
right?
burnt down, and it came to us, and, due to the amount of money he got through the insurance, and there was, a financial issue, it came to the commission, and we actually ended up approving it. But you're right, that's the exact same house, the one on Grand Avenue.
But it's a manufactured home.
And it's right
It
on,
was-
exactly, made thoroughfare.
Is it on wheels skirted or?
No,
Those
it's-
cannot
it's
be
a
on wheels.
Manufactured home.
Manufactured is not
It's
a
on a
mobile
foundation.
Oh, it's on a
Manufactured
permanent
homes that meet
foundation.
that definition that I cited do not have wheels or an engine. They are transported on a trailer and then lifted off and placed on the land. They have no wheels. They have no chassis of their own. They're only transportable on another trailer.
They're not
Okay.
intended to be mobile.
Okay.
And in most cases, once they're placed, they're placed. Apologies again for the
Several examples
clarification.
of manufactured homes around town. Some of them look okay. Some of them-
I sense that we may, all five of us being talked out at this point. Would anyone like to make a motion of any sort on this
I'll make a
topic?
motion. I'll make a, excuse me?
Yeah, we'll have discussion after there's a motion on the table. Yeah.
Yeah, well, I don't know if this is, I don't know if this is an appropriate motion, but it's a request, so let's see if it falls to the level of falls to that level. Can we just request that, this conversation today, and we incorporate, do we have to make a motion to incorporate all of the considerations that we discussed today, and for another review, and to continue this item. That's kind of what I want to say. I don't know if it's a motion or if it's a request or it's a motion. Okay, so my motion
it's-
is to.
it could be
is to
direction to
incorporate-
staff,
Yes,
yeah.
is to incorporate, and we can summarize those points of view into a new draft ordinance for our review at a continued date, certain.
Can I add one thing?
Sure.
The commission could do that. I just wanted to point out that at the March 27th city council meeting, the city council's motion was to direct the planning commission to provide a report back to council no later than the second council meeting in June of 2018, which we've obviously missed that deadline, but I think it does speak to a desire to have it back sooner rather than later. But
The
and so
next council meeting, I think, is late in August,
August 28th.
right? Okay.
And so, so I just wanted to point that out so the planning commission can keep that in mind. But having said that, that is something that the planning commission can move to do.
So your motion is to
Continue the item, but direct the
continue the item.
staff to incorporate all, the list of considerations that we just went through and update the ordinance for a second review. Not saying we're gonna approve it or anything at this point, but
Okay.
at this point, there's so much in it that needs to be
Council has to include the-
clarify.
clarified,
Yeah.
that I think, I can't recommend it to the city council in the form that it's in right now. And I may not be able to recommend it in the next form, but I need to see it in the next form.
I'll second that if.
You'll second that motion.
Yes.
Okay. Discussion of the motion. All right? Let's have a roll call on this motion to, you said to continue. Are we continuing to a date certain?
I would say
And
we
if
would
so,
have to,
what?
and I would say August 1st.
We can continue
To
it
our
the-
August 1st
Yes.
meeting. That's 2 weeks from now.
Yes. So we'd have
Is
to
that
continue.
doable?
We would
Yeah.
have to continue the public hearing because we won't have time to post new notices or anything, but it's doable if we continue the public hearing.
Okay, so
And if a
it's-
decision is made at the August 1st public hearing, there's still time to get it noticed for the next council meeting, although I confess I don't have the calendar for the next council meeting in front of me, whether it would go at that item or not.
Yeah, August 28th, I recall, is the next one. They've,
Oh, no, it is the next meeting. I don't know what else is on that agenda.
Hmm.
But it would be useful if that was was an option. Although, as Mr. Vega noted, the council had directed that the PC make a decision, but nonetheless, it's your choice.
yeah, okay. And discussion of the motion, then. I have a comment. I could maybe live with running the staff through this one more time. My preference would be to recommend to city council that they not adopt this subsection L in any form. And so, on that basis, I think I would vote against the motion. Any other discussion before we vote? Okay, Sherry, would you call the roll, please?
Mark,
No.
Corbin,
I don't know how I feel. I'm concerned that, we'll go through this again and maybe again, and then we'll give it to the city council and they'll say we want to do it anyway.
Well, that's up to them.
It's up to them. We don't have a choice.
That's ultimately what I'd like to do, is kind of volley it back to them in a better form, and let the public vet it out in that
Make our
in that
decision
format.
later.
And I'm torn because I somewhat feel the way John does as well, that I think I understand why people want it, and I also understand the pitfalls of it, so. But, okay, I'll agree let's do it one more time.
So that's a yes on
That's
the
a
motion.
yes.
Nolan,
Yes, and I just want to make one comment. I feel like what we're doing here is we're vetting it. We're still figuring it out, and that's kind of what you have to do on any ordinance.
Yeah,
You have
it
to go
does.
back and, maybe in the end it's not going to work, but you have to vet it and go through this process.
Yeah, I
to
don't
get
see any
there.
other way to get
So I'm
to
voting
a
yes.
place, yeah.
Quillisi,
No.
Jagiello.
Yes.
Motion passes.
Motion passes 3-2. And we'll be back to do this again in 2 weeks.
Oh, hopefully we'll have vetted a lot of this stuff already.
Maybe so.
Kind of get to the just
And
core.
we'll,
And then we can get to the
consider it
ultimate,
again
the
in 2
ultimate
weeks.
decision, you know,
Yeah.
of yes or no, you know. But at least we won't be fighting. No, I meant fighting the, yeah.
I understand John's point, too.
Yeah,
What we've
it's just-
decided to do is spend a little more staff time on something that we may ultimately
Have a little recess. just-
disapprove. Oh, certainly.
wanna-
Oh, we'll declare a 5-minute recess. the City of Ojai Design Guidelines. And the recommendation is we review the status of the various city design guidelines for downtown Ojai and adjacent areas and consider a recommendation of the City Council on modifying and/or creating and adopting additional design guidelines for the downtown area. Could we hear from staff, please?
Yes, thank you, and good evening, Mr. Chairman, members of the commission. In November, the City Council requested that the Planning Commission review the various design guidelines that apply to portions of Ojai Avenue and make a recommendation as to whether the Arcade Plaza design guidelines should be applied to properties on the east side of Montgomery Street. Your staff report includes a summary of the 4 different design guidelines that apply to the downtown area or portions of the downtown area and easterly to Oak Glen Avenue on the east side of Ojai. At the top of page 2 of 4 of your staff report, there's identification of the 4 various design guidelines. The first one is the Ojai Redevelopment Area Statement of Theme. As our staff report indicates, it's very general in nature, basically identifies Mission Revival as the preferred architectural style, but provides very little in the way of guidance. There's no graphics or illustrations or standards per se that go with that. Further, as you know, the redevelopment area has been dissolved, the redevelopment agency has been dissolved, so there's a question of whether or not these are in fact even applicable. And that area is outlined in blue on the map that is attached to your staff report. The next set of guidelines is the East Ojai Avenue Design Guidelines. These apply generally to properties from just west of Montgomery Avenue, the properties immediately west of Montgomery Avenue, all the way out to Oak Glen Avenue along Ojai Avenue, East Ojai Avenue, and generally apply to the first tier of properties. Those are that directly are adjacent to Ojai Avenue. These are, I would characterize as traditional design guidelines that provide guidance, pretty clear guidance to designers, the public, and staff in terms of what is desired there. Not only that, but it identifies several different various types of architectural styles that are included within the area and can be applied within this area. The next set of guidelines, which were adopted in June of 2001, so roughly 6 months after the East Ojai Design Guidelines, are the Ojai Arcade Plaza Architectural Guidelines. And similarly, they are a traditional form of architectural design guidelines. They apply only to the block that includes the Ojai Arcade and the Arcade Plaza, and it's outlined in green on your map. Again, these are what I would characterize as sort of traditional design guidelines, provides clear guidance to decision makers and staff, designers as to what's anticipated there. It very much reinforces the Mission Revival exclusively, architectural style exclusively in this area to build upon the design of both the arcade as well as the properties on the south side of Ojai Avenue, which include the post office and Libby Park. And the last set of guidelines are the arcade storefront guidelines, which were adopted in 2004 and apply only to the storefronts of the arcade itself. What's the result of all of this is that you have a situation where the east portion of the downtown and Ojai Avenue extending out to almost to the city limits have very clear design guidelines. However, the westerly portion of the downtown have no guidelines whatsoever. And because you have these various layers, for example, the Chevron station is governed by 3 different sets of design guidelines. So it's sort of a little bit of a hodgepodge, a mosaic, if you will, of design guidelines that apply in these areas. This could be remedied by modifications to the various design guidelines, by resolutions that modify their boundaries. The East Ojai Avenue design guidelines, as I said, do a good job of identifying various architectural styles, and could actually be perhaps even extended to apply to the VMU areas adjacent to the downtown. So you might have a situation where your core area does use the arcade guidelines to reinforce the Mission Revival architectural style, but the adjacent areas, largely zoned VMU, could actually have the East Ojai Avenue design guidelines extended to apply to them, because you do have various architectural styles within those areas, craftsman, bungalow, what have you. So that's kind of the status of design guidelines, and we welcome your thoughts and direction.
Okay. I do have a question. The Ojai City Council minutes, at least to the extent that they were provided in the packet, that is attachment F, says that Mayor Pro Tem Wyrick asked that a topic be considered for placement on a future agenda, presumably a city council agenda, applying the Arcade Plaza design guidelines to any development on the block east of Montgomery Street. I'm curious, the block east of Montgomery Street goes from Montgomery to Fox on the south side, and it goes from Montgomery to, Drown on the north side, and includes the school district property, the skate park, and a whole bunch of other commercial property. And so I'm not sure what at the time, Mayor Pro Tem Wyrick's request was, and I don't see a specific requirement, as stated in the staff report, that the Planning Commission take up this complex set of guidelines right now. Not that we shouldn't. I think it would be a good idea. But it's not clear to me that we've been required to do that. Second, I applaud the map that you've given us, but I confess that the overlay right in the middle, I guess that's the redevelopment area design guideline area, the coloring in there has tricked my eyes to the point where I'm not sure what applies to what. And I'm thinking back in particular when we did this brewery over on the southwest corner of Montgomery and Ojai Avenue. I thought the commission was under the impression, when we took up that case, that there was no design guideline applicable to that particular parcel. And I think this map says that the East Ojai Avenue design guidelines in fact apply there. But that was not mentioned in the staff report at the time, and so I did not consider it. But I am still not clear on which particular parcels have which design guidelines applying to them. The dark green, the Ojai Plaza Arcade, looks to me like it's most of the block between Ojai Avenue and Matilaha and between Signal and Montgomery, but except for the storefronts, yes. But then is this little green sort of reverse mirror image of Utah kind of shape? That's the East Ojai Avenue design guidelines. Yep. So that's the Chevron station?
Correct.
Mm-hmm.
Anything else?
And the stores that go up to the corner here.
And,
like
and some of the stores
shops.
on Matilaha, but not all of the stores on Matilaha.
Correct. That's a situation where you literally have 3 design guidelines that apply.
And yet that's a continuous building from the southwest corner of Montgomery and Matilaha. And is that, I mean, there's a massage parlor, there's other stuff on the second floor. Is that all covered by the East Ojai
No, the
Or
Mexican
is some of it covered by the Plaza
See this
Arcade?
color?
It's all covered by the Plaza Arcade, and a portion of it is covered by the East Ojai.
Might be an overlap.
Okay.
It's an overlap.
Yeah, so the
within the
Chevron
redevelopment
station is just Plaza Arcade?
No.
No,
Or it's
three.
It's also East
It's all
Ojai?
three. It's three.
The Chevron station is subject to the redevelopment area design guideline
Yeah.
and the East Ojai area, East Ojai Avenue design guideline, and the Ojai Plaza design guidelines, all three.
And are they consistent?
Mostly.
No, they're not.
Arguably no.
Arguably, no. If I could, just before the questions, I think the council issue was raised as a result of the landmark designation of the high school, and whether or not, because the the grammar school,
The elementary school, yeah.
because it is mission revival,
Right.
whether or not the Plaza Arcade design guideline should be applied to that property as well. To your question as to whether or not the Topa Topa Brewery was subject to the East Ojai design guidelines, the answer is yes, it should have been. And actually, it is consistent, but it was not.
It is. The
It was not
commission
part of the
didn't realize it
evaluation.
at the time,
That
I
is
think.
correct.
Yes, Kathy. I'm sorry, Mr. Summers, did you have a response to my question?
I was just, the other point that arose, I think, started part of the beginning of this conversation, is that that brewery property on the south side of Ojai Avenue at Montgomery is not subject to the Ojai Plaza Arcade design guidelines. And
Right, that's only on the north side of Ojai.
right, and I think that's another one of the questions that the council has asked the commission to consider. Should that be extended south or east, or just east?
Okay, a part of that
all.
question might be, do any of these design guidelines apply to any PL parcel? Certainly, the school district parcel is one of those, but the redevelopment area, for example, covers a part of Libby Park.
Yes, they do apply to PL zone properties.
Okay, the East Ojai,
East Ojai specifically. The Libby is within the, Libby Park is within the redevelopment theme area.
yes, which seems to be the most vague, perhaps, of all the design guidelines, but do any of the others apply on the south side of Ojai Avenue?
Yes, the East Ojai.
The east end.
East Ojai Avenue design
Okay.
guidelines do.
Oh, and I see they go all the way out to Oak Glen and Gridley. Okay. Yes, Kathy?
This is a suggestion, because obviously, this is kind of confusing. I mean, there's all this overlap. So I would like to propose that we start with maybe deciding, well, first of all, to say, yes, it's confusing, and to get to a place where we could say, let's break it out so we don't have all these overlapping areas. And that's not to say that the information within all these 4 design guidelines is not good or valid, but it's probably sorting it out. And I think a way that may work would be, what if we had a set of general guidelines that ran through the commercial VMU area, and then we had sub-guidelines for specific areas like the arcade or a special area? And what else did I want to say about that? Oh, I don't want to seem like we're over-regulating, but there's a couple, I think, what I would call broad stroke things that we need to think about. In other words, like, why do we have these guidelines in the first place? And I think it comes down to, like, connectivity between the entire commercial area. Like, right now, it's like the downtown is the hub, and then you kind of forget about the east end, and you kind of forget about the west end. And it's all pretty much about this downtown core. But I think there needs to be a thread of commonality that runs through the entire district. Now, I understand we have all different styles of architecture, and what could that be? Maybe it's trees. I'm just throwing that out there as an example. But the other reason I bring this up too is I think about the economic vitality of our commercial zone. And I mean, I've talked to members of people like tourists or even members of the public standing, downtown. And it's always like, oh, that's too far to go, like 2 blocks down, or it's, oh, I didn't know that was there. So there's a real disconnect between the entire commercial and VMU area. So I would like to see us trying to find, some commonality and a connection, both visually, and it might be something really simple, like I said, maybe it's the trees, but it's also for the economic vitality of the entire downtown. I don't want this exclusive, one side or the other. And I'm just going to share a really quick story, and this was something I heard on the radio, and it was several years ago. It was on an LA channel, radio channel, and they were having a contest. It was Elmer Dills. I don't even know if he's still alive, but he was like a food restaurant critic. And I happened to have it on because I couldn't get reception on anything else. One day I was working on a Saturday at my house, and he said, oh, today the prize, whoever wins this contest is going to get to go to L'Auberge, which is no longer there now. It's Nocciola, and to the Hummingbird Inn. And he goes, oh, well, L'Auberge is right downtown. You can just walk from the arcade there. And then he goes, but the Hummingbird Inn, it's like way out of town. And I thought, what is it, like a half a mile? And he started describing it. It was so disconnected. But I never forgot that story, and because I know a lot of people think of it that way and the separation. So I've said a lot, but I think you kind of get where I'm coming from.
Yes, Bobby.
Well, my store's at the corner of Ojai Avenue and Fox Street. And when we first opened up in 2009, it was like considered to be way out of town. It has more to do with what's along the road.
Yeah.
And whether there are destinations, because now it's not considered way out
If
of
we're
town.
doing real commercial
Because there's-
infill, then it's all going to seem
Right,
connected.
and one of the things that I read about in the East End Design Guidelines was talking about all the varied styles of architecture and having open spaces, and then it, in the same breath, talked about pedestrian-friendly streets. These open spaces are not pedestrian-friendly. If I go to a new town, I'll kind of do an overview, and then I'll figure out where I want to walk. And if there's all these open spaces, people are just going to drive there. I mean, I think the design guidelines, they're too many and they're too complicated and too specific and too vague all at the same time. And I would like to see a more consistent guideline. I also go through it, and there's so many pictures of things that don't necessarily relate to anything that we have in town.
Yeah.
I look at the school buildings out my window all day long when I'm working. And it's a really simple geometric shaped building. I'd rather, if there's going to be pictures, I'd love somebody to talk about the things that are good about that style, and not as a specific architectural style, but as design guidelines for any style, and how they're simple and they're geometric shapes, and the arches have a nice rhythm to them. They're a little more interesting than the ones in the arcade because they're flat, and then they have, different kinds of trim at the top of the columns. I think what troubles me about the architecture that I see in Ojai, and the Chevron station certainly looks like they tried to do every single guideline on every single elevation of this building. And is it nice architecture? No. It certainly isn't. And it's a gas station, I think that when I see what they're doing in Santa Barbara, that's still in keeping, but it's vibrant, and the massing is wonderful, and the colors are wonderful, and the trim is wonderful. And then if you look on, what street is it? near Metropolis, that little restaurant, there's this complex of residences. They're Spanish, but they're modernish. I mean, they're just beautifully designed. The massing is wonderful. They're dynamic. And I feel like a lot of what we get here is dead and brown and not interesting. And I really wish we could do better. I mean, I think that it's so overwhelming to look through these so many pages and so many pictures of things that aren't even in this town, that it makes for a very, we have facade architecture. It's not, it doesn't have life to it. It's just kind of, everybody tries to pick something that maybe looks old-fashioned, but that doesn't necessarily make it good. And maybe, you know, this is a big project, these design guidelines. We're not going to do it starting at 9 o'clock at night. You worked on these things, and probably you could give a lot of input as to where you were going with this. I think it's something you always say. I think it needs to be simpler, and I think it needs to give people the opportunity to create something as opposed to just trying to fit the bill or get approved.
Or copy something from Santa Barbara?
Oh, well,
I don't know.
I wish we could copy something from Santa Barbara. No, I mean, it's not even that good, you know. But it's something, it doesn't allow for something that's new and fresh, because that scares everybody. And you can use those same building materials and do something that's wonderful and vibrant and new, and both, you know, and it looks up to date. And then there is new technology. I mean, as you go through architecture and you go through design, new things are based on new technology, and we're not acknowledging any of that. And yes, I think you want to have some consistency at some level, whether it's through colors or trees or streetscape. But certainly Ojai Avenue is a car-oriented street, and we are not pedestrian-friendly, and our facades are not creating that either. So I think this is a really big issue, and I think it's important, and I think we need some time to address it.
Just something that ties into this, you know, hopefully the city will go through with the ATP grant, the Active Transportation Grant, that the Public Works Department is working on. And what the main part of that grant is providing pedestrian access, bicycle, and then tree planting from starting at about Gridley. Maybe it's Fair Oaks, and then going all the way to the Y, and then connecting to the 33 up to El Roblar, which is basically our commercial district. So I'm hoping that, you know, it comes to fruition, but once again, there's that pedestrian access, bikes and trees, so it could diminish to a degree, even though I know it's a state highway and a main thoroughfare, the vehicle traffic. But once again, that could be providing a connection. And it does relate to the design guidelines to a degree.
We won't be converting a state highway to a pedestrian wall, but there's more that could be done.
Right, so pedestrian access would be available, whereas right now it's not continuous, so
I'm also
that's
afraid,
important.
yeah, I'm also afraid of adding another layer of complexity to this school property, because I think developing that is really important for the town of Ojai, for the future of the town of Ojai. And I was not thrilled that they put that historic
Landmark status.
yes, because it's just going to deter any developer looking at it, when those buildings have to come through the planning commission, and we're not going to let them tear it down. There's no way. So I think if we add even more stuff to that whole complex, it's never going to get well developed. And I think that's a really important part of the future planning of Ojai, which we need to do. We need to talk about how we want that whole east end of Ojai Avenue developed and identify some things that would be wonderful to have. Of course, we're not going to have anything if we don't have water, but that's a whole other issue, and that's...
Mr. Quilisi,
Yes, sir, Chapster.
say something on this?
Please.
Looking at it from, looking at this thing from just a pragmatic view here, it sounds like one of the first things that we need to do is, which you've already done, was isolate where everything is and the boundaries, but we have to kind of separate out the boundaries as well. We can't have overlapping concerns. I think that causes more confusion. I think what's needed for me anyway would be a matrix that outlined the four major guidelines, seeing which ones we have in common, because there's going to be a lot of them that are going to be in common, and understanding which ones are not and why they're in a particular area, to see either we can get rid of them or we can apply them across the board to everywhere else, in the goal of ultimately coming up with maybe a one set of guidelines, a general set of guidelines with maybe some specific requirements for, like the arcade or something like that. So that's how I would approach this. I would ask staff to come up with that matrix, because we really that's the only way we're going to know there's a lot of good guidelines in here, and I think they overlap. And I think if we could see that there, we can come to a consensus on a general sense of general guidelines that could apply to most of the areas.
Yes, that's true.
I think
Exactly.
the redevelopment area design guidelines, since the agency for which they were drawn no longer exists, we might take a look at the first stage of simplification, which is, I think, one of your main thrusts, would be to look at that redevelopment area design guideline and say, is there anything in there that is not duplicative of the other guidelines to which the same properties are already subject? And if it's completely duplicative, then I would like to recommend we just get rid of that document.
Well, see, that's what the matrix
and then
will
we
do.
can look at the others.
That's exactly what that's what that matrix will do. We'll
Right.
see the common ones in each one, and that's why I don't want to approach each one separately, because it's going to cause more confusion. That's why we need to see all
I'm
four
already
of them.
confused by this.
I know, this is confusing. Yeah. So that's,
Kathy?
Yes, I have a question for staff. I know this is per City Council's request. Are we limited to what the area on this map, or can we extend Ojai Avenue to the intersection of the 33 where Vaughn's is? And can we include the commercial portion on the 33?
I think the council's looking for your recommendations.
I would recommend that we do include the commercial.
This is
Yeah.
primarily a whole set of design guidelines, overlapping or not,
Right.
that apply to commercial property in the city.
Right. But I just want to make sure that.
But there's a
topic
bunch
that-
of VMU up there north of Matilaha, for example.
Right.
Is that commercial property? Well, it's VMU,
So
so it
it
might
is.
be.
It's mixed use, basically.
mixed
But
use.
the VMU goes a lot farther north as well, and so one of the questions might be, do we want to start applying any of these design guidelines as we simplify them to all of the VMU area?
yeah, and then
And
We
do we
do.
want
We
to
do.
extend it south of Ojai Avenue as well as the rest of the commercial corridor?
right, I think it's twofold. One is
Right.
obviously creating boundaries, whatever that is, and also creating the actual guidelines. So to me, getting the guidelines clear, first of all, is like more priority, and then setting the boundaries, I think, can be more simplified, because it really should apply across the board, more or less, because these guidelines should have enough flexibility in them to incorporate just about anything we want to do,
And a
and
single
yet
step.
adhere, and then we can isolate
With special
just the real
areas.
specific, maybe a historical, unfortunately, that, Chaparral Building's now in historical.
arcade.
So you have to,
Yeah,
yeah,
you can't touch
well,
landmarks.
yeah, you could put landmarks in a special category, and that's it. And then we can get rid of all the overlapping boundaries, and
And if we had a single general set of design guidelines,
it's so simple for
that-
staff
that
to
would
actually
unify the
apply to,
city
yeah.
right there.
Exactly. That's my suggestion.
Too.
I'd like to make a couple
John?
of points.
Yeah. You had a hand in
Several
creating
points.
all of these,
I did.
except
And they
except
were-
the redevelopment
I
area.
wasn't involved in the 1983 redevelopment area, no, but everything else, yes. Each of these was created for a specific reason, but I love the idea of consolidating them all into one document. And I love Commissioner Corbin's idea of making it a really living document, something that really has some excitement to it that we could really get excited about. I did want to say, no one was here when we got the first proposal for the Chevron station, but we were really happy that we had these guidelines in place when Chevron came in with their standard corporate package, which could have gone in Irvine or Fresno or anywhere, and we were
Well,
able to
it
say.
would have looked more like manufactured housing than,
Oh, yeah.
yeah, than
It was,
Mission
it was,
Revival.
it was an awful design.
Right.
And we were really happy to be able to
So
say,
what-
you know,
yeah.
you have to comply with these
Right.
East Ojai design guidelines, come back with a different
Yeah.
thing. And there was a lot of back and forth about it, but we
General.
were much more excited about what they finally ended up with than what they started with. But I love the idea. I just think it's a real opportunity right now that the city council has kind of handed us to take all of this stuff and consolidate it together and make it into a document that we feel really good about. And then we can talk about extending it.
Right, exactly. And
Exactly.
then we can talk about boundaries. So I think we got to get the guidelines first, and then the boundaries second, to me.
Okay. And I don't know when staff would be able to create this background data for us, the matrix. It sounds like it's a fairly
It's a big job.
onerous
big job.
It's a big job.
job.
But that's what's
And
required for us to really dissect it and change it. We can't do it
Right.
without it.
I
you know.
think so.
And
At
staff
the
would have,
same-
yeah,
I'm sorry, go ahead.
well, we're saying the same thing. I think city council will have to give that authorization for them to work on a project like that. Because they would do most of the work for us, and then we would then be able to, I think, add a lot to those guidelines once we can see them laid out in a way we can go through them methodically. But we can't, it's gonna be too hard to go through them like this, and
Right.
somebody's gonna have
Back
to
and
organize,
forth.
somebody has to organize it.
Right, okay. At the same time, I would make a request of my fellow commissioners, and I'll take on the job myself too, of course. And that would be that you please go through at whatever speed you think is appropriate, go through the design guidelines, the 4 that we have right now, and just tag things and say, I think this ought to be in the general guidelines, or I think this ought not to be.
Yeah, or
Just
question.
as your initial take on the design guidelines, and that'll give us a basis for looking at the matrix, whenever that could be done, I don't know. Since, I don't know, we need to make a motion to.
Yeah, I'll make a
request
motion.
Staff, I'm sorry? Yeah, it's a discussion item, it's not a public hearing, but if there is, we'll suspend the discussion here on the commission for a moment and ask, is there anyone in the audience that wants to comment on this topic?
Yeah, now he's already started, actually.
Okay, that's fine, thank you very much.
I'll make a motion.
Okay, make a
I'll
motion.
make a motion that we ask staff to create a matrix which organizes all of the guidelines in a format and with the idea of seeing which ones overlap, so that we can then analyze those guidelines and to edit them in our in a future meeting.
With the goal of making a comprehensive
A
single
comprehensive
set.
single set with isolated areas.
Good.
And then we'll deal with the boundaries, and then after that process is over.
I'll second the motion.
Okay, we have a motion and a second. Any discussion of that? Sherry, can we have a roll call, please?
Merck,
Yes.
Corbin,
Yes.
Nolan,
Yes.
Quilisi,
Yes,
Jagielo.
Yes,
terrific.
more work for staff.
Chair Quilisi, can I just add or perhaps clarify something from the staff perspective?
Sure.
So I think that is a logical process that makes a lot of sense. I do think we will need to ask council to, to direct us because it is a substantial amount of work.
Yep.
Sure.
But I don't foresee any issues, so we can put a staff report together.
I think council would probably like to see this work done. It's a matter of time and staff hours, schedule and staff hours as to when it might come back.
Yeah, this is on their city council goals for the year. This is one of the projects on that list, so I think so.
Good.
Yeah.
I think we're of one mind on that then. Okay, our next, I've started as well. Our next agenda item is director decisions. Could we hear from staff, please? Anything exciting here or entertaining?
Nothing to specifically point out, Mr. Chairman. You note that there are tree permits, several sign permits, as well as temporary use permits and a couple of director's exemptions. But nothing of note to bring to your attention.
Okay, pruning oak trees, there's just a size limit on the size of a branch you can cut off unless it's diseased or something, right? That's what we're talking about?
Correct. We require a tree report that
Yeah.
justifies whatever action is being requested.
And I see the first one is remove one dead coast live oak. As I walk around town, and my wife and I do that quite a bit, we are seeing a lot of oak trees in particular, and some other varieties as well, where it looks like somebody ran a giant blowtorch across them. There's big patches of dead leaves just on the outside of the tree. And I'm wondering, are you seeing more of this?
Yes,
It
much
looks
more.
like, it looks like
Much more.
water shortage, of
The-
course.
The drought has stressed these trees significantly.
It was the heat spell that we had.
And then it was 119
Yeah.
for 2 days in a row.
It
last-
started like a couple days after, you could just see it, and you can drive down the highway. I mean, even in my own backyard, my own trees and shrubs, some of them just got blasted. But it was from that heat, especially
From the
that one
heat, okay,
Saturday,
yeah.
yeah.
Okay. Okay. Any other questions of staff on director decisions? All right, let's go to future agenda items. And I see design guidelines might be continued from July 18th, but I suspect it's going to take longer than that.
Yeah, I would.
And
Yeah.
we've made a request. We're not trying to continue the item to a date certain or uncertain at this point. It'll have to be renoticed and I think at some point, a public hearing will be in order for new design guidelines. So that's going to move out somewhere. Landscape standards.
Yeah.
Is this your doing?
I didn't put it right there.
Oh, okay.
But I will help do it.
That will be ready.
That will be,
That will not be ready for the August 1st.
okay.
Yeah.
But we are gonna do movable tiny homes again.
Yes, we'll have tiny homes, and we also will have, it occurred after this was printed, but we'll have Boku DRP on the 1st as well.
And can you give us a clue as to what that's about?
Yes, so Boku is asking to add the ancillary uses for manufacturing / processing in their facility, which is right on 987 West Ojai Avenue.
Yeah, I'm familiar with the area. I was on the commission at the time that they first came in, but I thought they were already using one of those buildings for mixing powders and making other stuff, and they called that processing. So I'll be curious to see what other processing it is that they're requesting leave to do.
So that is the processing that is part of this. Under the city code, packaging and processing. Oh, okay. Yeah.
Clearly, it's an item of great interest. That's not on tonight's agenda. We'll discuss that at your next meeting.
Okay? All right. Discussion items. Assigned by the city council, hedges, fences, and walls. Oh, Lord. Okay. Planning Commission code cleanup. I think it's maybe a little early to start that, but in the next couple of months, I would like to get each of us to volunteer to do a chapter or two of Title 10 and make suggestions as to how to clean it up.
Maybe we assign them at some point, you know,
Right.
to one of us, so we don't duplicate and do the
Yeah.
same.
Oh, yes, right. And clearly 10-2 is the big dog, and that's gonna take a heck of a long time. Probably two of us ought to take that. But I think it's very important that we get code cleanup underway. I see water-wise development standards. I thought we had done that.
Yes, it's actually being prepared to go back to council.
Okay, so we can take that off. Tiny homes, yeah. Design guidelines. Changing VMU categories from industrial/com to, commercial to special district. I think we're gonna need some help understanding what that's all about. And ADU legal non-conforming status definition. We're gonna need some help on that. But we could.
We'll bring information on this.
Movable tiny homes in Boku might fill our next meeting anyway. But maybe August 15th, we could take up the ADU legal non-conforming status, and maybe you could talk with us then about the consideration of changing VMU categories. Beyond, I suspect that tiny homes is probably, if we haven't either exalted it or killed it on August 1st.
It'll be the last time we look at it.
I hope it's the last time. Design guidelines is gonna be farther out. Hedges, fences, and walls, I think we'll need a little guidance from staff as to, or from the city council, as to what they want us to look at. Because my personal impression is that the municipal code is pretty clear, but the last time somebody tried to enforce it, we were talking pitchforks and tar and feathers. So it's not clear what the planning commission can do to help that situation, but maybe we can talk about that on August 15th. So maybe we can catch those first two on August 15th and then move along, and we'll get back to design guidelines when staff can provide us with some background information.
That works.
Any other suggestions as to what to pick up here? And I do think that on August 1st or August 15th, we need as a group to decide who's going to start looking at what pieces of the code. Okay? Next item, agenda item 6, Planning Commission liaison schedule. And I see the first one there, June 12th. I was still recovering from surgery. I apologize. I did not do that, but I will commit to you that I will go back and watch the entire June 12th session, and I will report back at August 1st, whatever was there. I personally think it's more efficient if one of us attends the meeting and then spends 10 minutes talking to the rest of us about it, rather than everyone having to sit down and watch the video through the whole meeting. I think the former is a much better use of our time as a commission. June 26th, Commissioner Corbin.
Okay, well, I did not go to the meeting, and I
some
Good
of
for
the
you.
items
Yeah.
because I watched the ones that I was the most concerned about. And there were two. I mean, I do know that the cannabis issue was passed.
That was later. That was my meeting that I went to,
I read in the papers.
July.
That was July 10th, yeah.
But that was on this agenda too.
It was, it
Yeah.
went to
It was
different
carried over.
numbers, and then it got
So the two
finally
issues
passed.
that I
again on July
watched
10th.
were about the water coordinator position. And it was approved that, in theory, that there would be a, creation of a position, a staff position to coordinate with all the water activity that's going on so that we can be well informed about all the different agencies and what they're doing, and somebody whose responsibility it would be to advocate for the city of Ojai. And I think staff was directed to further define that position and figure out how it might be funded. And then the other issue that I watched was about fees, and it was largely about planning and building fees. And there was a report about the cost of services and how much was recovered by the actual fee. And in fact, typically 100% of the fee is not recovered. However, the issue that was brought up, and it was a very good issue, was efficiency standards and accountability. So it's one thing to say, this is how much it costs us to do the planning, and this is how much we've gotten in fees. It's another thing to talk about how the money was actually spent. And I think therein lies the problem, which is that a lot of things are contracted out. And I know personally, when I asked for an accounting of how my money was spent, I couldn't get a real response to that. And that's not appropriate, because if somebody's spending thousands of dollars of your money, they should know where it went and why. It's not enough to say, well, we paid this person for 10 hours, well, what did they do? And I think that and the response is, well, it's your project, you're gonna pay for it. No, you hired them, I didn't. And if I hire somebody, I make sure that I know what they did. And it's kind of, especially with planning fees, it's an open-ended book, and you just, I mean, a year and a half later, I got a $100 bill for I don't know what. And then somebody talked about how letters and emails are not charged for. That is not true, because I know personally that of emails and letters that were billed for. An inquiry, did such and such happen? No, we're still not allowed to do that because Caltrans says there's a drought, and then a bill shows up for writing that letter. So there's a lot that needs to be looked at. I guess there was a report that said that our contract service provider fees are high. And God, I sure hope that city council does not approve raising the fees, because the fees are crazy here. I mean, I don't know what they're like in the rest of California, but I know in the rest of the country, they're not like this. Not even close.
Yeah,
And
welcome
I
to
think that
California.
From having employees, I can tell you that if people work on an hourly basis, there's no incentive for them to work faster and more efficiently. And that the few employees that I'm allowed to bill a flat amount, my son being one of them, he gets his work done so efficiently. And, you know, I don't get paid extra if it takes me longer. I've learned to be very, very fast and very good at what I do. I think that we really need to look at fees in a whole different way. And I think that's as I've said before, part of why the tiny issue came up in the first place. It's how do we get around that? It's impossible for a normal person to build anything in this town. And, you know, some people have very deep pockets, and if that's all that we want to cater to, then that's fine, but that's going to affect the kind of town that we have. So it's a really important issue, and I hope the city council spends some time on it.
Thank you. Chester?
I didn't even have that on.
Yeah, got it.
I actually went to the same meeting, to the one she reported on is the meeting I went to as well. I was confused.
Oh.
But the only thing I remember about the July 10th is what I read in the paper, that the marijuana cannabis thing got approved, and now next month we can all go down the block and get a joint after the meeting. Yeah. So that's all I remember, but.
It is adult use cannabis. I
Yeah.
didn't recall hearing, I was at that July 10th meeting. I did not recall hearing that there were any restrictions on where the adult use could take place.
There are restrictions on that. State law prohibits consumption of cannabis, whether medicinal or adult use, in any public place. The city has parroted that provision in its own code.
Anywhere along a sidewalk on a street? for
Any public
example?
place, sidewalk, in a street, in a vehicle, of course, in any publicly owned property, all of those locations are prohibited. In the privacy of your own home or your apartment building or your backyard is legit.
And in a vehicle is not?
No, that's prohibited under the vehicle code. The same rules that prohibit an open container of alcohol also prohibit
Yeah.
an open container or consumption device for medical or adult use cannabis.
I always thought it was interesting in the 70s when I moved to Texas that the law there regarding alcohol allowed for not only open containers, but it allowed for consumption of alcohol while driving. The law said you cannot drive while you're intoxicated, but it said you can drive and consume alcohol at the same time, so long as you're not intoxicated.
Texas is a
very libertarian approach.
different place than here.
Yeah.
Try that here. Good luck.
Okay. Commissioner Powers is not here for the June 13th Building Appeals Board. I did attend the July 11th meeting, and it was largely taken up with review of the first 7 or 8 chapters of Title IX. They made some very worthwhile recommendations on changes to the code that are passed on to the City Council. They also recommended that several of those 7 or 8 chapters be given to the Planning Commission because they were not building standards, they had more to do with land use and zoning in the view of the Building Appeals Board. So when that comes back around from City Council, if City Council approves those recommendations, then we are going to get some new topics to consider and consider whether they need to be added to Title 10 or whether we recommend that the topics be dropped. And that was pretty much all of the meeting. It was very efficiently run. I was pleasantly there and enjoying watching something that was detailed but moved along at a brisk pace and made some worthwhile contributions to the code. So, June 18th, MAC meeting. Commissioner Corbin, were you okay?
I didn't go to July 16th. Was there one? I didn't get a notification.
Was there a cancellation or something?
I didn't get a notification. Did you send that out, Sherry?
I think the July meeting was canceled,
I
yeah.
remember
Yeah.
getting that notice.
Yeah.
It came to all of us, I think.
Okay, well, this fair warning, August, we have 2
Brace yourself.
August, we have a city council meeting, a building appeals board meeting, and a MAC meeting. I'm sorry?
Well, there was?
Oh, but since they don't record them,
Yeah, I didn't get any
Okay.
notification on that. Did you? Okay.
and I will report back on the June 12th city council meeting at our next meeting. I think that's the end. So,
Council report?
yes. Commission committee reports. And did we have we didn't have a complete streets.
No, but I
Meeting in
rode in
July.
the parade.
Oh, well, that's, want to get that on the record.
Ojai bikes.
Yeah.
Flyer was attached, remember? I sent it to the whole commission.
What date was that?
Okay. Then,
The meeting for the public workshop on July 25th.
Right.
And then
What date was that sent?
it was sent on
okay.
the 9th,
Fine,
Monday
okay.
the 9th, July 9th.
Okay.
Okay, so we all know what has to be done in August.
Yes.
And our city council liaison, welcome to a new member for this quarter, Councilmember Blatz.
There it is.
My
Very
pleasure that I'm
handy.
going to be with you for the next quarter. Thank you. You know, the issues that come before this commission are difficult to say the least in many respects. I can remember, as I recall, Commissioner Merck and I were on the Planning Commission when we did the East Ojai Avenue guidelines.
We did both the East
Yeah.
Ojai Avenue and the Arcade Plaza.
And then I was on the redevelopment commission when we
Yeah.
decided, you weren't, but I was on the redevelopment commission at the time that we did the redevelopment area, so it goes back a long way. And I do think the best thing to do is to come back with a recommendation from the planning commission that you look at all of the guidelines, because I liked the discussion you had, except it came back here with a very narrow request, and that was because of a couple of things. One is the development just to the west of the Chevron station, and also with the school district building. Councilmember Wyrick wanted to know whether we should extend the arcade guidelines down to the east area of Ojai Avenue.
When he said 1 block east of
Right.
Montgomery, he meant the school district building.
Yes, yeah. And whether or not, I think he was looking to see whether it might be on both sides of the road, but that was the very specific request. And it was because of the fact that we wanted to make sure that any development that might take place on that next block would be conforming with the arcade guidelines, and also with the development that was in that little strip where we did the land swap. That was not part of the guidelines for the arcade. So that was part of that reason as well.
But it was
So
part of
come,
the
bring it
arcade
back, I mean,
plaza.
come back and say that you've looked at it, and you're requesting that you really have an opportunity to to really look at whether or not you want to revise all of the guidelines, because I think it's probably a pretty good idea at this point to do that. I don't think anywhere in our guidelines, though, we stifle innovative designs. I don't believe. We've seen some crazy designs come. We've had many projects that have come before this commission when I was on it that we said that's too much like Santa Barbara. But that was only because of the way that it was designed with multi-stories and things like that. But I don't think there's anything that I ever saw come before us that we wouldn't allow a modern thought. So hopefully it's the architects that aren't bringing those designs to us. I would hope that they would do it, you know? Yeah. I mean, I don't think for those members, because I haven't been on the commission for several years, I can't remember a project coming before you in which you denied it because it was kind of a modern look to it, I don't think.
Oh, there was.
Which one?
That land swap thing.
Yeah.
They came in with black painted steel
Uh-huh.
and stainless steel and such,
Right.
and we said.
But that's a little different than I believe what Commissioner
Well,
Corbin was
we're
referring to.
arguing about whether gray was a natural color. I
Yeah.
mean, really?
Yeah,
That's,
It isn't it?
yeah,
it is a natural color, but it was denied
yeah.
by city.
Of course, the council then, I think, overruled you guys and allowed that project, so. Or we sent it back for a redesign or something, as I recall.
Yeah.
Yeah. One comment I will make about the fees. Yeah, our fees are set by state law. We're only allowed to, we have to look to state law, and Mr. Summers can perhaps add to what I say. But in California, the fees that municipalities can charge has to be directly proportionate and related to the work that's done. You can't do a flat rate fee, for instance, just say that it's going to be this much without being able to say that it correlates to the cost. Is that correct?
The Prop 26, which is the rule you're referring to, requires that the city, in most cases, and particularly for planning and permitting fees, can't charge more than the cost of providing that service. The council can choose to charge less than the cost of providing service if they show that the subsidy for that service is provided from some other source, such as the general fund.
That's one of the things that we're kind of limited with from state law, that they govern some of the fees that we do.
Saying that it's the cost of your providing the service?
Yeah.
Well, I think that was what Bill Wyrick brought up, was the fact that sometimes the services provided is too expensive because it's not done efficiently and there's no accountability.
Right.
So that's the issue. The issue is, how much are you paying, and do you know why you're paying that amount of money?
Right, if you
And
recall,
the other
the
issue
individual
was that if, in fact, you require somebody to give a deposit towards whatever it's going to cost, and it's open-ended and you don't know, it's A, a leap of faith for the person giving you the money, and B, there's no incentive really to do it for less than that. So
I would agree.
I think that how you operate, or how your contract providers operate, it determines how much it costs.
That's very true.
And how much time is spent, wasted, there's no accountability for that. So that is really what needs to
Right.
be looked at.
But there is accountability as far as the council is concerned through the city manager, and the city manager through the community development director.
Well, that's another issue we
So-
can talk about too.
I did think there was one interesting point that I thought I heard from the call him a fee consultant, I'm not sure exactly. In partial explanation of why things cost more in Ojai than they might in other places. And it's once again a matter of scale. He said you might have a planning director and 3 assistant planning directors and 7 junior planning directors, and a lot of the work that might take place on any given job could be done by those junior planning directors or junior planning assistants or whatever you want to call them. Whereas in Ojai, we only have enough space to have a planning director and maybe one other person. And they have to wear many hats, and they wind up, as a result, costing more per hour than a junior planner would in Los Angeles or Santa Barbara or somewhere like that. And that doesn't completely mitigate, it doesn't speak at all to the efficiency, but it does speak to the hourly rate of Ojai's staff charging against any particular project.
Right, but, there were things done incorrectly on my, on the work that I paid for, and then I paid to have it done again, which is what happens when you do time and materials. That's not right either. They didn't even get my parcel number correct on it.
Are you talking about through staff? Well, that's something that you should, you shouldn't have to pay for mistakes. There should be an appealable process for that. I would bring that up to the community development director. Yeah. Well,
I got a sheet that was useless.
okay. Well, I don't know if you brought it to any of the council members' attention or to the city manager's attention, but you shouldn't have to pay for a mistake that staff did. That's not the way that we want to do business, that's for sure. Yeah. Well, I'm looking forward to it for the next quarter.
Yes.
Seriously. I like being the liaison to all the commissions, but this one is kind of close to my heart. So I
Right.
can't believe that Merck is still here. 10 years was the limit for me, and you've been around 10 more than
I
that.
keep thinking of David Hirschberg, who was on the commission
Yeah,
21
and
years.
March Fay, and
Yeah.
yeah. Yeah, that goes back a long way. Sure does. Thank you. I appreciate it. Thanks for all your hard work. It doesn't
Thanks.
go unnoticed,
Thank you,
that's
Mr.
for sure.
Barnes. Okay. And absent any other needs from the council or from the commission, we are adjourned.